Esteemed participants, distinguished guests, ladies and gentlemen, it is with profound gratitude and respect that I welcome you to the 4th edition of Legal Innovation Day, a conference dedicated to the most advanced legal tech solutions which are actually used by real professionals. This is not only the place where we display excellence in legal tech, but a place with a rare opportunity to convene, discuss, and share knowledge about what's happening in the world and how is this touching our profession. I'm humbled today by the assembly of the remarkable minds, each contributing to the vast mosaic of the knowledge and innovation in our field. We bear the responsibility and also the privilege of shaping the future and setting standards for the generations to come. We owe this beautiful setup to our generous partners, without whom this event wouldn't be possible. Please allow me to share their names: CITR Romania, Sierra Quadrant, CertSign, and Canon Romania. Our professional partners, Axis Nova Resort and Spa, Brico Depot, and Sora și Asociații. As always, we have the honor to have the support of our traditional institutional partners, the National Union of Bar Association, the Bucharest Bar Association, and the National Institute of Continual Training of Lawyers, INPPA. This event is broadcast through our media partners, the Finance Banking Legal Councils Association, Universul Juridic, the National Union of Labor Law Experts, UNELM, Juridice Ro, along with the support of our systems companies, Wolters Kluwer Legal Regulatory, from Poland, Germany, Czechia, Slovakia, and Hungary. I want to thank you all for your tremendous support. Without further delays, I would like to introduce our first keynote speaker, Mr. Roger Chrisman. Mr. Chrisman is a system technology leader, currently serving as Vice President of Product Software Engineering, Wolters Kluwer's Global Technology, in short DXG. And he is the CTO of Wolters Kluwer Legal and Regulatory. Beyond his corporate roles, Roger's entrepreneurial spirit has led him to nurture startup ventures which showcase his ability to identify market gaps and drive growth. His career began in management consulting in KPMG, and this provides him a solid foundation for strategic insights and transformational methodologies. He is a truly visionary, driving innovation and change across technology, so for legal solutions and beyond. Mr. Chrisman, please join. Actually, I'm truly intrigued by the title of your presentation, From Code Roots to Code, Human AI Synergy.
Is it working? Am I audible? I am. You're on.
It's on and it should work.
There you go. Can you guys hear me?
Thank you.
I'll instruct you to sit down. This is not normally the way I do presentations, but apparently for the camera. So, apologies for that. Let me get my deck on. There you go. So, let me start our morning. AI will replace lawyers. Do we wake up now? In reality, let's see if the clicker works. But in the end, actually about those who fail to adapt with. Of course, not to replace us. We'll have some really nice panel discussions afterwards. I know with Robbie's here. But obviously, we are using AI in our daily lives, whether it's to unlock your phone, or get into your car, or use autopilot, etc. Or even your spam filter in Outlook. So we learn to adapt. So I work for the DXG organization, so it's the central technology organization within Wolters Kluwer. We basically serve innovation across all of our different divisions. So that's not good. Okay, good. So effectively, we serve all. I'm in that management as well. I lead the CTO role of legal and regulatory. So what I'm going to talk about a bit today. You want me to take this one? You want me to turn this one off? Or you guys do that over there? Okay.
Good. I'll start with this one. I'm going to talk about 4 brief topics. One is the changing legal landscape, the thing you suffer through or actually experience every day. I shouldn't say suffer through, but you experience every day. Then I'm going to talk a bit about how AI is actually changing legal research specifically. Then I'm going to talk a bit about human AI synergy, and I really believe it's amplifying each other. It's about being stronger together, and then together we'll look a bit of a decade ahead about, so what does it mean for tomorrow, right, before we get the panelists on and have a discussion. There you go. I think, and hopefully you agree with all of us, and I grabbed something from our Future Ready Lawyer Survey of 2022, and the 2023 is coming out as well, so I encourage you all to actually read it. But there is a massive pressure on you as legal professionals. I don't have to tell you, you have bigger expectations from clients, from corporate legal departments, etc. There are bigger workloads, and there are, of course, tighter budgets. And hopefully I see some recognition here in all of this, but this is typically what we're faced with. When we also look at the respondents, and what we were getting back is that about 80% are coping with more increased volumes of data, more complex cases, etc. At the same time, we see a lot more legal departments having higher expectations of firms, and the same actually goes for clients. In general, actually, nowadays, our clients expect us and sometimes ask us, which technologies are you using to make it more productive, more efficient, and get better insights, right? And of course, through technologies like GPT, we actually see a large portion of legal departments and actually our clients are starting to use non-legal providers as well in the realm, right? So this is the, I wouldn't say threats, but this is the things that we cope with every day as legal professionals. You're rather nodding, that's good. Increasingly, I think, and again, this is from our Future Ready Lawyer Survey, we see increasingly firms realize how important technology adoption is. Has been, will be also in the future. I'm not telling anything new. Like I said, I'm actually expecting that arc to actually go up further, right? But at the same time, it's already near 90% for both law firms and corporate legal departments. Now, enter AI. When you look at each of those themes and patterns, and you think about advanced technologies, that's best to ask a technologist. Exactly, best to have a technologist on stage and talk about failing. Now let's enter AI. Reshaping coming from Wolters Kluwer, 1836, being part of a publishing organization, I think AI is for legal what the printing press was for literature, to be honest, right? We're at that new peak. And it's very simple. When you want to explain this, it's 3 key things. One is the unprecedented ability to process backwards human elevating it. So think about, I always look at it and I identify a couple of things. Like one is the understanding of legal language through natural language processing, NLP. The second thing, its ability to visualize complex data sets. And the last but not least, as we talked about it already, is kind of predictive analytics. I categorize it as 4 topics, like understand me. It needs to understand the language, the things that we're asking as professionals. Does it have context? User intent modeling is what we call it in natural language processing. The second thing is, can it enable me as a professional? Can it help me? Can it provide me practical tools like decision trees to drive and do my work more effectively and more efficiently? Then it's about supporting me. Think about it when you're day-to-day, how much repetitive tasks you do. And can you actually automate those things? How many of these simple questions can it actually automatically answer so you as legal professionals can actually focus on those things that matter, those things that are valued. And again, the examples there are chatbots or concept extraction or summarization. And last but not least, and this is something that we see as well, with that amount of volume and data, that's coming at us. It's also all the changes in regulations, laws, policies, etc. How do we monitor that? How do we keep track of this? How do we know if it's effective and applicable to me, my firm, or my department? Right? So it's about regulatory change. The technology behind it actually, and I think hopefully you've noticed, I'm not saying anything new, is not that new, right? So it started back in 1950s with Alan Turing, and then actually I think around 1960 the term artificial intelligence got coined, and then actually in 1966, it's a nice factoid for you guys to know, is when we created the first chat program, chatbot if you will. It was called Eliza back in 1966. That wasn't Walter Kluwer, by the way, that was another gentleman, unfortunately. Then there was a lot of other things that happened, but I need to be brief, so I'm skipping to 2012, when the deep learning revolution actually began. And it began effectively with Google identifying cat videos. So, wow, there's a lot of flickering happening. So if you, I hope people do not get any anxiety attacks.
She wants to say something.
Don't talk bad about AI, apparently. Huh? Shall I wait for a second, Adrian, or?
Yes, 1 second, of course. You know, when things can go wrong.
Perfect. I am perfectly. That's perfectly fine. Except, yeah, you could have put a different picture up instead of my big picture, huh?
Okay, it's a better.
It's okay. It's fine. Just let me know when you want me to continue.
I think we can go on and then we'll show the.
Just show the slides up if you want, and that's going to be fine. So anyway, so 2012, I'll just continue. But 2012, with the deep learning revolution, and that's actually the time that Google started to identify cat videos. So if people ask, like, why is the internet all about cats? Go back to this time, right? It's terrible. It's the first ones. And the second one is CNN at the time came up with AlexNet, which was also image recognition. So that's back in 2012. And then in 2016, that was actually when AlphaGo, and I know Pavel here is actually an avid Go player, defeated actually a professional Go player. It's an immensely complex game. Apparently I can learn it in 15 minutes, which I think is very interesting, so I want to absolutely take you up on that offer. But that was an epiphany, right? Moving on, again, I think moving on just very quickly to 2018, that's when, 2018, think about this. I need to do, wow, I get so many switches, screens, microphones. This is like, yes, exactly, well, battery after battery. I'm sorry, guys, are we still awake? By the way, thank you. Wow, okay, 2018. So 2018 was actually when the first version of GPT came to market, GPT-1. So it's not last year, it's 2018, right? And actually, very interesting, that was also when the Google Transformer model, there's a really nice paper to read on it. If you really want to understand how LLMs work, I can explain it to you as well. But if you want to go deep, there's a actually research paper called Attention is All You Need that's talking about the Transformer model. And actually, Bert, that was 2018, that was GPT. 2022 is actually when you guys all knew about ChatGPT. That's probably when you started to first hear about it, maybe use it already. And again, I know Magda might be doing some polling on that. So, but that's 2022. And actually that was GPT 3.5 or 3.5 when that came in. And I think they reached a first 100 million monthly active users in 2 months. That is incredible when you think about that, right? And then just fast forward very quickly, and then I'm done with my timeline. In 2023, now you see Microsoft starting out with those plugins, Copilot. They're starting to do this across their board. Bing has it, etc. Google released their equivalent of this called Bard against the G Suite. And then Meta, the Facebook company, released a new model with about 775 million parameters. So that's all the different things that a language model contains, which is huge. That's now, that's 23. So if you see that arc and how it evolves, that's really going up. Wow, and now I see that the mic actually is working. Perfect. I'm clicking here, I'm seeing slides, you don't see anything. But I know Adrian and team is working hard on that. Then my next graph doesn't make any sense, I'll skip this. No, the interesting thing about it, and I think I already said it, if you compare it to those things you do, let me just see, like Netflix, everybody's using Netflix here, probably took 3.5 years to get to 1 million users, right? Take something like Twitter, took about 2 years to get to 1 million users, right? And then Spotify, I think we're all use Spotify about 5 months. And then ChatGPT, 1 million in 5 days. So you see that it's just incredible when you think about those things. No, this is not a plugin for ChatGPT. So the thing we need to understand as well is just when you talk about AI, and particularly generative AI, there's 2 real types of AI in the world. I call it extractive AI. And extractive AI, or now called traditional AI, that's how quickly things go, is all about finding relevant data in existing patterns, in existing data. So it doesn't create any new content, it's just all about finding existing data. That's extractive AI or traditional AI. And then there's generative AI. Generative AI specifically is about creating new content, new novel content, etc. And the interesting thing is, many people now think that they all need Gen AI, whereas most of those use cases are actually done through, it can be in some cases done much more effectively through extractive or traditional AI. We shouldn't forget that. But it helps. Wow, there you go. I still see my face, no stress. The 3 distinct features, again, hopefully you guys, without slides, you still follow me, right? Good.
Online we can see it.
Online we can see it. That's a disadvantage for you guys driving here. Shit. Oh, sorry, I shouldn't be sorry. Oh, sorry about that. Leave that out. Distinct features of Gen AI. So obviously we know content creation. We talked about that. That is one of the key distinct features. So ask yourself always this: do I need to create new content with this? Is it going to do something novel, something that doesn't exist, isn't an existing pattern? That's a distinct feature of Gen AI. Then conditional outputs. So I can influence, I can steer it. That's known as prompting or prompt engineering. That is one of the key features as well of Gen AI. And last but not least, it's probabilistic of nature. So we always think it's super, super smart, but in the end, it's all about likelihoods in words. So it always chooses the next words based on the statistics most value. And that's why also you can with the same prompt get 3 or 4 different answers. And I can tell you, we love in technology, you hear the word hallucinations. We can also just replace that and call that lying. And it's really confidently in lying. And I think most of you guys have heard about the case, the airline case, where there was a legal case really nicely submitted, all the right references in there. They didn't exist, those references. So it's just plain lying. Be careful of that. We'll talk about that in a bit. Continuing, application. So, wow, really nice screenshots for those online. You can see the screenshots. No, actually, one of the key applications, one of the foundational use cases for all of us is, I think, summarization. I think that's one of the key things you think about. How can it actually consume and make it much more comprehensible, all that amount of data that's coming at us, right? Summarization is one of the key foundational use cases that we look into, obviously, as Wolters Kluwer. And there are 2 variants of that as well. We call it extractive summarization. So extractive summarization reads through content information, pulls out, doesn't it out that in a summary. So no alteration. Extractive summarization. That's when we actually create new content. And that's more complex because that we understand the real nuances of what's being said, what's in the content, and then we create actually complete new editorial-like summary. But those are kind of, when we talk about the summarization piece, be also mindful of those 2, because often so, the first one, extractive summarization, can be done through that traditional AI, right? We like to think it's all Gen AI. We can solve that as well through the other one. Make sense so far? Wow, good crowd. Wow. The other one is predictive outcomes. So we talked a bit about it, predictive analytics. Obviously, it's about providing user input and getting a desired output. So that really means about getting understanding of it, doing the NLP, and then using the language model behind it to actually pull and formulate that forecast based on patterns. All right. And the other piece on that one is anomaly detection. We can go through tons of data, define what good looks like, and then use that same algorithm, use that same capability to spot anomalies, because it's all about pattern recognition, effectively. And last but not least, legal draft assistance. I think, Margaret, you're going to show some of our products and screens later as well. But think about things like intelligent document drafting. We can use that to generate automatically forms. We can customize templates. We can use it for proofreading analysis. That's what we're always doing as well. So it can detect inconsistencies, but also it can come up with revisions. So effectively, if something changed in a regulation or policy, we actually use it to come up with policy revisions for us. Say, hey, be mindful, there is a change here, you might want to take that change instead of what you're doing before. And last but not least is, of course, we're using it for advanced clause and case referencing. As we type, we actually pull in and it suggests relevant references, etc. Right? So those are just some examples that we see. I'm looking there, it doesn't make any sense. By the way, if you could see this, you'll see a quote from Richard Susskind, who actually was here on, oh, you can, that's clever. Thank you, you're actually watching on your phone. I should have said that in the beginning. No, just kidding. Hopefully I'm articulate enough. So what Richard Susskind said in July on his blog, and it's, again, I encourage you to follow the man if you're not, or read his books. I think you've done this all at some point in your careers. But he actually made a quote, and he said, the most exciting possibilities of AI lie not in swapping machines and lawyers, but in, well, that's different, but in using AI to deliver client outcomes in new ways. And I firmly 100%, that's coming. Thank you. But makes so much more sense to look at a quote instead of listening to me reciting the quote. No, but in the end, I mean, the interesting thing about this is, and I fundamentally agree with him, there is effectively, it's really about delivering client outcomes, right? So really using it to our best abilities, using it to amplify ourselves. As we're going through, there you go. Yep, there you go. I'm one further, but it just doesn't matter. We're skipping. Oh, that's there. Ah, perfect. I go back for 1 sec. I blew the 20 minutes out of the water, Adrian, I'm sorry. This is the quote, so I'm not lying. Richard Susskind, who actually also coincidentally was the first speaker of the first one 4 years ago. For being here before, first one. So, shifting gears, he talks about human AI synergies effectively. And that's what I believe in fundamentally. It's about being stronger together. It's not about replacing, it's about complementing, right? So it's about how can we use our human intuition with a machine that is really good at calculating vast amount of data and amplify that together. Secondly is about optimizing time management. We talked about that before as well. Like let the machines chunt down those big data sets, come up, connect with multiple legal databases with your own systems, your own information, and let us then focus on case strategy, on the nuances, on the things that actually matter, right? And last but not least, use it for enhancing, obviously, your legal research. We can connect it to multiple repositories, whether it's Wolters Kluwer, whether it's your own firms, etc. And actually, we can provide it in a very comprehensive overview and insights for you. Again, saving you a lot of time and efficiency, I hope. Shifting gears. There's also ethics and ethical considerations, threats, challenges, and configuration. I mean, we had a very nice discussion over dinner last night. We'll probably talk about that as well a bit in the panel. But bias. Remember, garbage in is garbage out. So in other words, if there is bias in the data that trained the models, then there is bias in the output. It's as simple as that. The other portion is freshness. And I'll talk about that. I'll have a slide on that in a second. But be careful that not the data that's in there that you're using in your language model AI is not always up to date. I'll talk about that. The other thing is over-reliance. As human beings, we tend to, I have to say, we tend to be lazy. So if a machine can do the work, we trust the machine. Don't be like that Canadian airline case, right? Do verify checks and balances on this, right? It's good to use it. In the end, we as humans, that sounds great. We as legal professionals end up being accountable, so check, please, right? I always say trust but verify. And last but not least, when we're connecting multiple of these things or in your chat and asking things, think privacy. If there's one cornerstone of the legal profession, it is really client confidentiality. So make sure that we are all putting that at our priority. That's at least for us as Wolters Kluwer, it remains and has always been our priority to do. So talking a bit about freshness, this is the data set, and there's a chair in front, I'm sorry. But just look at the link, and I'm sure that this is going to be available also offline. This is the C4 data set that's being used to train large models. This is effectively Google's training set that was also used for Lambda and for others, and GPT doesn't disclose which training set they had, but my assumption is the same. Only 4% of that data is law and governance. If you go to that site effectively, if you Google this, you can actually look which sources for legal it has used, right? By the way, GPT-4, January 2022. That's when their knowledge stopped, right? So that's as simple as that. If you want to ask real-time things, it's not in there by default, right? Think about that. Shifting gears, and I think I'm almost there, Adrian, and then we'll get to the panel. When I look a decade ahead, where are we going? One of the key things and one of the key use cases that we're working on from a tech perspective is what we call retrieval augmented generation. So what does that effectively mean? That effectively means, like, how can we, instead of having to change an entire language model, how can we actually append it? How do we actually send a query, a question you guys have, into our or your systems, use that data as context, and then send that back to a large language model to summarize? In other words, you get the best of both worlds. You get kind of this general large language model that provides the language. And the second thing, we append that with the context of the data that you have, or that we have, or that we combine together. So I encourage you also read up on retrieval augmented generation, or RAG in short. And I often refer to this as vertical AI, where that's going to be the next stage. Then the second thing is integrated legal platforms. We call them expert solutions across Wolters Kluwer. That is really where we combine everything like research, drafting, analysis, all in an holistic platform. And last but not least, I'll talk about human AI collaboration. So AI assistance, conversational search, adaptive learning to your preferences and as an individual. So not as a professional, but as an individual, that's going to be new. And I cannot really talk about something in the future without talking about augmented reality. So I have to mention it. So something at some point in time, we'll be all sitting here with goggles on, but well, not now yet. Maybe in a decade, we'll see, right? So with that, I want to thank you, and sorry for some of the glitches, but hopefully I still made a lot of sense, but I think I did. And thank you for the excellent suggestion on following it on your phone. That was great.
Thank you very much, Roger. Before inviting the other guests to the podium, I would very much want to ask you, you said about augmented reality and in 10 years. Can you elaborate on that? What can we expect?
Can we elaborate on that? Like, you picked the thing that I thought, like, I can't talk about the future without mentioning that. No, I do, but look, I think in a times of hybrid remote working, in the time is of the essence, I do believe that having the notion of having things, and again, we need to see where augmented reality in general is going, but the ability to have, we're sitting behind our desks crammed, for me, it does make more sense to have things tactile, to have things projected out there, and to be able to drag in different sources and things. So I think technology-wise, we're getting there. I think right now it's always very clunky as to what we actually see. I mean, have you ever been into the metaverse, any of you? Yes, you have? And have you experienced it hybrid? So when half of your group is in the metaverse and the other half is not. That is a terrible experience. So again, that's full virtual reality. So I don't think that's going to go where. But the middle ground, so that more tactile view, is going to be there. Look, again, we'll have to see. Apple just came out. I'm just going to see what that's going and how we just push on that price. We'll see. We'll see what that happens.
In Star Wars, it worked. You know, they had a Jedi Council, and it really worked somehow.
That is scary. Sorry. Yes. So when you think about those things, and it's scary, right? So when you go back, and if you look at Star Trek with those sliding doors, shit, we have sliding doors. Actually, hell, when you go back to the Jetsons, who knows the Jetsons here, the cartoon? Yeah, okay, there you go. Yeah, my generation. So the people, no, but look at it again, and then think about how many of these things we have today. It's shit scary. So you're saying about your Star Wars, I think we're going to be there at some point, 100%. Right? Hope that answered your question.
Thank you. Thank you very much again. So I would like now to invite the first panelist to join us. We have Ms. Magdalena Kasmarek-Krupa. She's lead technology product manager at Wolters Kluwer, but she's a very interesting person. She combines law, a law degree with technology master in project management, and she's leading a lot of projects both in Wolters Kluwer and in previous positions she held. Then I would like to have Mr. Radu Sora, a managing partner of Radu Sora and Asociații. He's now a member of in the Parliament. As we all know it, Parliament is of higher importance. So we thank you again for the short notice term that you are here. Of course, Mr. Grosu, he has over 25 years of experience, holding all range of positions from small lawyer to the head of a legal department of a company of over 25,000 employees. And last and not least, Mr. Pavel Lako. Technology, technology lawyers. He's a partner at law firm Muțova Lako Advocața Cancelaria. I'm pretty much sure that I slaughtered this name, but I hope this will be understandable. He is a partner at the law firm, and he's working in Slovakia, and he's also an external lecturer at Cornelius University in Bratislava, focusing on subjects related to private international law and international arbitration. I thank you all for being with us today. Of course, glitches are, technology, it's foolproof as always, but we hope we'll manage. So, Roger, you have the floor. Thank you.
Thank you. And I think we're straight going to go in a series of presentations. And I always there's always one guy that always is forgets to unmute on a meeting. Let me be that guy today, and let me be the first. Adrian, everything from now on will be great, I'm sure. So, Magda, I think we're going to start out with a presentation from yourself. So we're going to do, each of us as a panelist, I've done my talk. Each of the panelists will give a presentation, then we'll go into Q&A, and I will do my best to steer our way through this with this crowd. So Magda, with all means, please go ahead. Here's the magic clicker. All right, there you go. And you want I'll give you I'll give you my mic.
Yeah. At least we are sure this one working.
Yeah.
Hello, welcome everybody. In my presentation, I will try to be more concrete than Roger and show you how it might influence your work in reality, how to bring cool stuff what Roger mentioned into our daily work as a lawyers. Okay, maybe first we will show the QR code, if we may. Okay. Okay, so I will go ahead and then we will proceed with the QR code. Okay, but right now I cannot see my slides.
Da.
And I cannot switch.
Ia-l din Teams.
Yes.
So,
Și spune ce vrei să faci. Păi trebuie să deschizi Teams-ul ca să-l găsești.
the first one. The first one. Yeah, great. But it is not visible over here. I can see it.
One moment.
Okay.
But we'd like you to prepare your phones because
Yes.
you'll need to scan that in order to be prepared to respond. The online users are already seeing it.
Yeah, so if you have your phones, you can scan this QR code. And please wait, because when we will move to questions, you will see those questions on your phones, and you will be able to vote. But you will not see this question before we will move slides. So no worries, there should be only white screen right now, but you will see questions later on. Can we fix over here, or?
Yeah. 30 more seconds, 30 more seconds.
Okay. So maybe meanwhile we can switch to the next slides, and I will start. Oh, it was here. Okay, here we are. Over here there is QR code, but also you, if you have troubles with QR code, there is also a link and code you can use if you are not able to scan the QR code. So please join us also in
Sorry
this
for the
presentation.
flickering, unfortunately.
Yeah, they're blocking the QR code. Thank you, Bogdan. Exactly. Well, there you go. That's what I said.
Yeah.
That's synergy.
And we can see a human cannot be replaced. Okay.
Perfect.
I hope everybody could make it and was able to scan.
Let us see. As always, unfortunately, the screen.
There you
It
go.
should work.
Yeah, we have 27 people already voting, so I hope it works. Okay, so maybe we can move to PowerPoint and.
Yeah, let's go.
More PowerPoint.
Yeah.
Next.
Okay. So we recognize like 4 categories of legal search. We are doing every day at our work, and first category, it is expanding theoretical knowledge. So sometimes we are in the situation that law is changing, for instance, or we are hearing something and we would like to find out more about it, just to know if it influences our work or not. So we are just asking kind of general questions. It is not case related. We just want to expand our knowledge. This is the first category. The second category is case understanding. So me as a younger lawyer, when I'm dealing for the very first time with this type of case, I need to have like more high-level overview what I need to do. Or maybe for me, it's the first time I'm dealing with this kind of case and I need to grab some high-level knowledge. So still, I'm trying to first formulate quite general questions to find some relevant things related to this case, but still it is high-level knowledge. The third category, it's legal problem solving. So it is more in the context of our particular problem, particular issue we are dealing with. It is still quite general question, but more deeper, related to a specific legal problem or situation. For instance, when we are asking about tax interpretation, something like that. But I think the most relevant is claim point search, because usually, at least at my previous profession, I was searching for specific detailed knowledge related to my case. So I know who was the court, who was the judge, what kind of participants I have in my case, and I was searching for very specific point related to very specific point inside my case. And I'm just wondering if we can right now move to the question number 1. What is your opinion? What kind of legal search do you perform mostly? Please, if we can switch to the question. Yes. Yeah. The first one. Using your phone, you can vote for those questions. Yes.
Ooh. You see some results come in?
Yes, we can see. We can see that legal problem solving is the highest one. That's interesting. We'll give a bit more time. That's really interesting point of view. I think nothing will beat legal problem solving column, so we can move back to my presentation, please.
Mm-hmm.
So, I hope, okay, it is switching in unexpected way. I will do the switch, okay? I hope most of you are still familiar with traditional legal research, so with books, reading books, trying to find some knowledge in a paper way. I still remember when I was at the university, we did it like this. We used books mostly. But then, more and more, there was digital transformation. So companies like Wolters Kluwer, we moved our content, our books, into digital form. So you will be able to search through this in more effective way. And we started to develop and put our knowledge into research platform. You probably know this one. This one is from Poland with lots of filters. This one is from Italy, for instance. And Navigator, or it is in view from Netherlands. So right now, this is those are those tools I hope you are mostly using. So you are going to Wolters Kluwer products to search for legal knowledge, but also most of us is using Google. But then generative AI came to the picture, and right now we have lots of opportunities how we can search through data and how we can improve our legal work. Rohier also said about some words about this. And if we can move to question number 2, I'm also very curious. If you have ever tried generative AI for any kind of purposes, if you could please vote. It doesn't have to be work-related, but for your trips, planning your trips, or generating some poems maybe, or songs, or images, whatever. I'm just wondering if you tried it out. Yeah, but we can see lots of people did. So that's great. So you have some experience with that. But also, I'm wondering, what is your biggest concern? What are your biggest concerns about using generative AI at your work, at your legal professional work? We have some suggestions over here. If you could please vote what you think is the biggest concern.
Wow.
So you are right, Rohier. Data privacy is the topic number 1. This is the biggest concern, and it's definitely more higher than everything else. Great to know. Okay, can we please switch to presentation again? Okay. So, as Rohier also mentioned, generative AI is good for some things and not so good for other. And over here, I pointed some things for which generative AI works pretty well, and pointed also some things for which it doesn't yet work so well, but we hope it will work better in the future. But also things you should be also careful about, because also, as Rohier mentioned, there were not so many legal data which trained those models. So that's why also we have lots of hallucinations over there, and we really should be careful for what kind of purposes we are using generative AI. But it doesn't mean that it doesn't give us lots of opportunities, because it does. And previously, with the traditional research platforms, as we saw, we were focusing on the second point. So we have content. But right now, using generative AI, we can go to the point number 4. So we can draft verdicts or decision or legal documents using our content in more efficient way. And it gives us lots of opportunities, but it will take some time till we will get there. But that also means that we need to change a little bit of our behavior, because what we are used to put some keywords, phrases to get some search results. And usually the search result list we need to validate on our own. We need to read those documents which are over there listed, go into each of it, or try to, based on some kind of knowledge, try to figure it out if it's something relevant to my case or not. So we were focusing mostly about keyword generating, which keyword I can use to get the best results, or which keywords combination I can use. And with generative AI, we have the possibility to change our habits a little bit, but it's also a challenge because habits is a strong thing, and we need to change it a little bit if we want to have better results. So if we want to have more relevant content, if we want to have draft of document, memo, argument, or whatever, we need to also provide more insight to the tool, so the tool could provide us the correct answer. So that's why keywords will not be enough. And I will show you in a moment how we would like to do it. So we have like 4 groups of possibilities how AI does right now or will support lawyers in the future. First, we are focusing on reduced time of search result list review. So we are trying to develop solutions which will help you to validate this result list. So you can, from visual perspective, understand quicker if it's something relevant to me, to my case, or I need to skip it. So this is one trend. The second one is provide less but more relevant content, because right now when we are trying to search through some keywords, usually those results lists are quite high. Like we have like hundreds of results, and maybe the most relevant one is at 50 page. Who will go over there? Probably no one. We will stop at the first, second, third page maybe, and the most relevant thing could be on page 50. So right now we are focusing also how we can improve that, how we can show less but more relevant content. And the third box is provides answers to the legal questions, because right now those ChatGPTs and other tools are teaching us to ask questions instead of keywords, and we think that generally this is how we will expect things to work. We would prefer to ask questions in our natural language. For us it is legal language, and expect that the tool will create the answer. So this is also what we are working on. If it goes about the first box, I have some examples from our experiments. Some of those things are just in experimenting phase, so don't expect it tomorrow at the market, because we are still experimenting about, but just to show you what we are thinking about and how it may look like. So this is summarization. Because, as I said, to go through all jurisprudence, read each verdict to see if it's something relevant to me, it is time consuming. So we can ask AI to make a summarization for us, so we can read the summary and see if we need to go deeper or not. This is first example. The second example is from Polish research platform, and I think you have something alike in Romania. So we are able to highlight different parts of verdict just to be able to read it quicker, or if we are interested just in arguments, we can just click on arguments and see all arguments in the verdict instead of reading 20 or 30 pages. The next one, it is about search query assistant. Sometimes it is very hard to find the right keywords. Because we are trying and still we are not pleased with the results, and we are trying with other keywords. So here it is a tool which we can write however we want, our query, our case description, whatever, and it will transform into keywords. And we can see keywords generated by AI, and we can select or deselect those which are not relevant in our opinion, but still we can get some more closer results because of this analysis. The next one is case analysis. Because Sometimes we are just searching for arguments, so the verdict is not so important itself. It is those statements which are mentioned in this verdict are more important, and this is what we are searching for. So we are trying to change the behavior. If you will provide a little bit of case description, what you are dealing with, we are searching for arguments inside verdicts and showing those arguments and showing the graph if it was successful in a like case or not, and below the list of verdicts which are in which this particular argument was mentioned. So we are changing the result list not to present just verdicts, but arguments and 10 below verdicts. The next one is ask a question. So as I mentioned, I think that we will go into direction. We would like to have a quick answer to our question, and that will also be in the legal profession. So me as a lawyer, I would just like to ask a question in my natural language, so legal language, and I would expect the machine will provide me answer right away. Sometimes to create this answer, it is time consuming because we need to go through lots of materials, commentaries, see some patterns, and so on, analyze lots of data, and machine can do it. And this is also what we are working on, how we can formulate a quick answer to your legal question. And over here, we are experimenting with Google, and I wanted just to show you the difference also Roger was mentioning. So over here, it's the same question for the both slides, and one is what Google right now is answering us. And the second one, on the left side, it is how we can answer using our content. So we are using Google technology, and which is trained on our content, on Vortex Clover content, and we are generating the answer using Gen AI. And over here we have like traditional AI from Google, and also we have a little bit of summary, but we can see the difference between those two things. And also, I think which is really interesting, how we can bring this knowledge to some kind of work document. Over here we have an example which is memo, but it could be potentially also something else. So how we can change the search result list into kind of document. This is also something we are working on. And if we can please switch to the last question, forward question.
We're out of time, so we'll do the
Yeah.
last question. Yeah.
Okay. I presented you several options, and I'm just wondering, what do you think? Which of those tools would be most useful for you? What do you think? What would support your work best? Over here we have no favorite.
Ooh, be careful.
It is changing. So maybe let's give a couple of more minutes.
Seconds. Yeah. There you go.
Still
Okay.
questioning in natural language is the highest one, but also summarization look
Yeah.
quite high, almost same. Really nice.
Makes sense.
Thank you for this. And if we could move back to the presentation. The last thing I would like to show you is a product which is right now available at some markets. I hope in Romania also it will be available soon, because searching through content is one thing, but bringing pieces together is another thing. So besides we want to have a search more effective, we would like also to work more effective, how we can use the content in more effective way and combine our knowledge insight from our law firm with Wolters Kluwer content in a real document, because this is mostly what we are doing. We are creating documents. So this is a legal assist, Word add-in, which right now brings content from the research platform to your Word environment. So you don't need to switch between Wolters Kluwer research platform and your Word, because you have Wolters Kluwer content in the side panel. And also what Rohir mentioned before, we are notifying you if something has been changed, because we are using templates or previously created documents in our work. Or our younger lawyer is sending us something to check. And we need to be sure if the reference fits our needs. It doesn't mean always that it needs to be up to date, but it needs to be correct on specific point in time, because when we started the case, it might be different. So over here, we can alert you if something is potentially wrong in your work document. Please check the reference. We can also read the Wolters Kluwer content next to your Word, so you don't need to switch your screen or whatever. You can also read the content of Wolters Kluwer in your Word environment. And also what we are trying right now is to improve your legal search in your Word documents. Let's say I'm using a template, or I had a like case a few years ago, and I want to reuse my lawsuit from that case now, because it's pretty much alike. But I need to be sure if it's still up to date. And I need to check, for instance, if some new jurisprudence was created between the time I create this lawsuit and now. And over here, we are also trying to improve your legal search by generating keywords automatically from this document and show you more relevant content for Wolters Kluwer. For instance, additional jurisprudence which is not directly mentioned in your document, but also relevant to this case. So this is what we are working right now on, and I hope you will like it. Thank you so much.
Wow. Thank you, Magda. That was a lot. That was relatively long, but a lot of information and a lot of practical information. And yes, indeed, a lot of products that we actually are working on today in multiple languages in multiple countries. So no, thank you for highlighting that. Next up, Bogdan, if I may give you the mic. And I'm very curious on your talk.
Thank you so much. Thank you so much, Roger. I am a lawyer that works in this field for 25 years. In these 25 years, I'm sure that you understand that I used a lot of AI. Everybody's using it. And like, for most of it, it becomes somehow an addiction. An addiction, I don't think it's good for. It doesn't matter which kind of drug you're using; it is not good. I see it. I see the AI, and I see everything related to cybernetics and AI. I see it as an addiction, and I want to talk a little bit, if you remember, we talked about AI as a threat or a critical advantage. So, recently I was in a discussion, I was in a debate, where there were 2 professors and 4 lawyers. And the conclusion somehow it was that AI, it's first a threat. Why? Because realistically speaking, if coming back to the first slide that Roger had, it was like that. AI will replace lawyers who fail to adapt with it. But from this statement, I understand, I am compelled to remark that AI will replace lawyers eventually. When I'm talking about failing to adapt to AI, I believe a very important thing is, what do we want from AI? Do we want that AI will steer our lives, or do we want that AI will be a help for us, an aid? For instance, if I'm coming back a little bit to the very nice line of questions that you had. At some point, I saw that there was a question where the people voted mostly to have the solution. And the others, the secondary place, it was to give information about the solution. It was understanding the case. I wasn't on the side of understanding the case and not having the solution. I want to take the solution by myself. It's a point of view.
Yeah.
There was another one, which it was also very relevant. Which solution would you support the work for you? And the most people chose that they want AI to be a legal assistant, ask a question or made a request. Very close, it was the other one. No, it was jurisprudence summarization. So I believe it's a little bit of a fight for all humans between what we do really want from AI. Do you want to be helped? Yes, or do you want to be to take the decision for us? If we remember that AI, it's in a very tight relation with cybernetics. And if you think about what does it mean cybernetics, Kubernetes, it's a Greek word that means basically drivers, the one that steers, the one that controls. It's about control. Personally, I don't want to lose this control. And for this reason, I'm on the side of AI. I'm using it. I don't know if you saw that when I came here, I put my phone here and then I open my computer. So I'm not a guy that says that denies basically electronics, denies digitalization or AI. I'm using it all the time. I'm trying to use it in a way that does not affect my capacity of taking decisions. I believe it's very important for lawyers. I believe it's very important for judges. The judges should be free and should be free to take decision, but I'm sure that in the name of efficiency, because this is the problem right now, AI appeared because we all need efficiency. Yes, and for this efficiency, we are ready to pay all the time, and we are paying with data. We are paying with losing our privacy. We are paying with losing somehow the privacy of our clients. We are lawyers. It's a very sensitive area. How can we know that that data, it will not appear in a data leak? For instance, not long ago, I just received a mail that I have to change my password because it appeared in a data leak. And that was it. So Google said something like, okay, I'm sorry, it happened, that's it. And I just have to change my password. It's not really okay to be treated like that. And for me, this is one of the main concerns when talking about AI. It's about privacy, it's about losing control, and I would really like to use everything, but I want some guarantees that this technological advancement will not make me basically dependent on this kind of electronics. And you see, I'm already dependent. And I'm trying not to quit, but to give some level of freedom for my mind. For instance, I know that Voters Club have analytics. Analytics, I believe it's an extraordinary tool. But sometimes as a lawyer, I want to go against the odds, because there you'll see in the analytics that you are entering in a field, I don't know, labor contracts, or I don't know, construction. And you'll see there that the judgments that were given are something like 90% for one party. And you are, let's say, on the other party, somehow on the losing party. You have to fight. You cannot leave it as it is. So you have to fight against the odds. But what does it mean? What does it happen when the judge uses the analytics and the judge sees that somehow the other party should win. I'm like a sitting duck going there. So I cannot say that I'm not an AI enthusiastic. I am, but I want limits. I want limits because, yes, in this moment, if the question is AI a threat to the legal profession, I say yes, but in the same time, it is a critical advantage because if I don't use it, I will lose in terms of competition, the competition with the other law firms, with the other legal professionals. So there is a very strong conflict about this, and I really believe, as a lawyer, from a bar with more than 10,000 lawyers, which I believe not everybody is as tech savvy as the ones that are present here right now. We have to think somehow also about them, what we should do with them, because I really believe that there will be some lawyers that will not adapt, and somehow we owe them something. We have to help them to adapt.
Agreed.
Yeah. So I don't know if I already finished my time, but basically that was the thing that I wanted to tell you. And the message is, again, do not think about the limits of AI and do not lose control. Thank you.
Thank you. And look, what we're going to do, out of the interest of time, we're going to do all the presentations first and then come back to some Q&A. But like I said, it's always really good to be a criticist, like to say, like, look, it's an advantage, but at the same time, what does it mean? Data privacy came out, run clearly, and obviously when we talk, remember this, data is also your IP. This is something, like you said, we need to be very specific about it. This is where we are also with our data. We do these things, and that Magda was showing, we do them in a very controlled environment, basically on, and you were just showing that on some of the screens, on a controlled piece that we own the data, that it doesn't go back in the language models, it doesn't use our data or your data somewhere else. We secluded that, and that's the same with privacy. And that's what we absolutely need to do. I also like the part, like, how do you, and this is sometimes the piece we forget. We love to use it, we love to take that response, but how does the system get the answer? That's going into the realm of explanatory AI. So there should always be a notion that says, I see the answer, click on a button, how did you get that answer? Because that is how you think, and then you see, like, okay, I see the pattern. Exactly, and I think that is a key point, and that's a great point that you've made. I think we're going to go straight to Bogdan. And by the way, I did agree with everybody. I was able to use your first names in order not to butcher them that much. So thank you, Bogdan. Here you go.
Welcome, Roger. I will start by confess. Here today in front of you, I confess. I'm just another lawyer, like him, with also 25 years of experience. And I allow myself to talk about him because we are colleagues, not only as lawyers, since high school when we were playing basketball, not in the same team, but often one against the other. But that's not important, because what's important today is that I come in front of you for two reasons. First of all, to talk to you about what the National Union of Bar Association does in the field of digitalizations and what it's important and how that helps, first of all, lawyers and true lawyers, all the citizens. And the second, it will be a few words about what I think about the digitalizations and the impact on our lives. I will start briefly with the first topic, and I will try to be very short on that, knowing that probably most of you know what means a memo of 10,000 words for a lawyer. Ring a bell? I'm sure it does, and I will say it for you. It's a brief introduction. Coming to the most serious part of my intervention here, I'm speaking now in the name of Daniel Fenechiu, which is the Vice President of the National Bar, National Union of Bar Organization, which should be here, but being a senator also, he was retained at the Senate with urgent matters, so he asked me to present what has been done in that field of digitalization. And as we said at the beginning of that event, being the first who does something, it's collecting, it's summarize all the educational experience which hurts the most in that field. In other words, the lawyers has been the first profession, the first liberal profession in Romania which passed a law on the digitalization of the profession. And that was rewarded by our colleagues with a massive opposition. So massive that we finally decide to postpone that law, which is now in analysis, in order to find the next best solution in order to digitalize the profession. That will help, of course, all the other profession. And we will see how it's going to be done. What I think it's worth to be said here, it's the fact that the most opposite reaction from our colleagues came from things related to the security, to the privacy of the data, and the confidentiality between on the relation between the client and the lawyer. We've gone maybe too fast on that, but we will not stop here. So our professional organization will continue to find the best way to digitalize our activity, because clearly we cannot do it without.
It's going to
Be done, we will see. Maybe we will finish by integrate some of the tools that have been presented here today. We certainly integrate much of the know-how that is discussed here, and we will come in the public sector, and we will present more clearly the benefits on what we are doing. Aside of that, maybe some of you, maybe all of you already know that we have that portal, which is in Romanian, cautavocat.ro, where all the Romanian lawyers are who choose to be there. It's not a professional obligation, it's a professional choice. Are more accessible to the public demand. And clearly, the digitalization will continue, and that's the main direction chosen by our professional organization. Besides on that, passing to the second point of my intervention, and that it's personal opinion. I think that what's really matters now is how it's going to be after digitalization. We will implement. We just talk about the most accessible solution to digitalize, and what's going to be after, because there are plenty of questions raised on privacy, on security, on. Finally, we as humans, we will still exist after digitalization. What's our future? And on that, personal opinion is we will still exist, and we will be more beautiful than we already are. How is that? Because we have plenty of components in ourselves which are not used very much today. And I'm talking about emotional intelligence. I'm talking about our components which are linked to the emotions, which are linked to the spiritual side. We invented that tool, digitalization, which takes away very much of the work, repetitive work, which we do not like anyway. And we will finish by have very, very, very much time disponible. It's our choice, every one of us choice, to decide that we'll stay in the comfort zone or we will go to the learning zone, even if sometimes going too far in the learning zone, we will find ourselves in the chaos zone. It's our choice to learn how to come back in the learning zone, to find a way in our inner comfort zone, to reunite ourselves, and from there to continue our own development. On the long run, I think this is the way that things are going to happen. It is not, I think, right now the most important moment to talk about that, because we are on the digitalization event. But after that, after digitalization, it's going to be about how we can better flourish than we already did it. What's important in all that for the lawyers? Let's not forget that the lawyers are those who speak for others, advocates, we were called in imperial Roman times. So we choose to speak for others. That's why it's mandatory to understand how humankind functions. And if we manage to understand how artificial intelligence functions, I think it's easy to understand how humankind functions, because artificial intelligence modulated the humankind way of functioning. That's why I think it's a new frontier for the lawyers. We will have plenty of work to do in a different way, I know. Charles Darwin told that a few years ago when he first wrote in Origin of Species that it will not be the most intelligent, the most kind, it will be the most adaptable species that will survive. So it's about every one of us to decide, to choose when and how much we'll adapt. I think it's the way to do it. And I invite every one of us to follow us, the lawyers which already made the choice to continue on that very nice road, I think. And because my 2 points of intervention finished it, I thank you for your kind attention, and I give back the microphone to Roger. Thank you very much.
Wow, thank you. And again, I hope that I'm looking at the side to see how much time we actually still have, but I hope that we can go into a series of questions after this as well, because to be honest, I think that the relationship you're drawing with emotional intelligence is very strong. Adaptivity as well, right? And I think that that's a good point, because when you did the poll, we saw a lot of people actually have been using generative AI. And we go through this curve and saying, well, be very skeptic, and then we go like, hey, this actually works, and then we try it more. But then when you really start to embed it as part of your work, that's we get into that cycle to say, but how? And do I actually want this? Does it replace me, or does it replace the way I work? And again, I think that that's what you were hinting to as well. It's no, and I think hopefully we get some time to for me to ask some questions specifically on it. But first, I want to go to Pavel on a presentation. Is that good? By the way, so there's no, sorry, because I have to see this guy, so I'm looking at these gentlemen here. I'm the Dutch person here, but I'm at the same time the smallest person here. So thankfully they're sitting down, because these two gentlemen are actually, if we stand up, they are much taller than I am. So I'm not very much representing my species over here. So, Pavel?
Thank you. Can I also have the clicker?
Yes. There you go.
Okay. Okay, so first of all, I'd like to appreciate that I have been invited to this event. Thank you very much. And as you see, my presentation will be about the perspective of a small law firm. I'm an attorney from Slovakia, and you see that there is an A missing there at the end. And you see that to err is human, and this mistake makes the presentation more human and less artificial. So you see that it hasn't been done by artificial intelligence. And so I today will be representing the, let's say, the small people. Yes. So we are also here. Small law firms are also here. It's not just Financial Times front page deals which are occurring. We also do some legal work, and I will talk about the perspective from a small law firm attorney from Slovakia. That means in different countries you can have different perspectives, but we have some issues I just want to raise. In respect to my presentation, I have taken the advice of two people. One of them is a professional Slovak TV presenter who said that you always should have a hard copy of your presentation available, yes, if the technology fails. And the second advice is from Professor Patrick Winston, who is a lately deceased AI researcher from the MIT University. And he was once approached at an airport by some random guy, who asked him if he could review his presentation. And he just said, there are too many slides and there are too many words on each slide. And the guy asked him, have you seen my presentation? And he answered, no, but it's always the case. So I tried to make it, my presentation, to make it as succinct as possible, so you can concentrate on what I'm saying and not read too much words. So yes, starting with the first slide. So basically, my topic is research from a small firm perspective, and legal research. Let's say that in the last 15 years, I have seen the major shift in legal research to be connected within these three major areas. Why 15 years? Because that's the length of my practice. Yes. So I'm not a novice, but I'm not a veteran either. And these three topics are connected with the stuff where I have seen the most major breakthroughs in the last 15 years. So the first one, search, yeah, that's connected with research. That's obvious, yes, that's self-explanatory. The second one, content creation. This is something rather new, and how it's connected with research. Well, content creation, from my perspective, it's search with some upgrade. Yes, you search, and the result of the search is wrapped in a nice package. Yes, and the third topic is connected with translation, which is again some search which you then modify to a different language. So these are the three major topics I'm going to talk about today. So, going to the first one. Yes. So search, you see there are not many words on the slides. Can be divided into two prongs, yes. The first one I call legal commentaries, and the second one judicial decisions. So legal commentaries, I mean, this is not just really commentaries per se, but it concerns also articles, recommendations, and other legal literature. So maybe the proper term would be legal literature. And where I have seen the biggest shift is that, I mean, there has been search available for a long time, electronic search, but what has become a lot easier is that the search itself is very easy. I call it's Google style. Yes, you can search by keywords, by author, by date, etc. So it has become a lot easier than it used to be 15 years ago. And also a very huge advantage is copying. Then you can copy a huge amount of text which you need in your briefs, to your statements, to your contract, yes? You don't need to retype the stuff again. So this is a big time saver and money saver. Where I see a disadvantage, and which is also an opportunity for legal software providers to come in, is the disadvantage that it is not, everything is not under one roof, yes? So not all sources are at one place, at least in Slovakia. I mean, with respect just to research, we are using 3 to 4 different providers. So it means 3 to 4 different softwares and apps, and this still doesn't cover more than, I would say, 50% of all the legal material available, because it's exclusivity of journals. They want just to be connected with one publishing house. So in order to have different opinions, to be able to find all the information on a topic, you need to have more software providers, more software apps. So this is one disadvantage that is not connected. I mean, it's not really a question of money, because the software itself not that expensive, but it's a thing of, let's say, usability, because I need to be able to use 3, 4 kinds of software which have different layouts, different updates, etc. So it's something which can be improved. Of course, when I see it from a perspective from 1.5 decades ago, you need to look for 100 sources. Now you have 3 or 4. So it's becoming a lot easier, but it's still, it would be much appreciated if you just could use one method, one software, and it could be interconnected with other sources. Yes, I mean, I wouldn't mind paying more money, but if I just could use one app. So this is with legal commentaries or legal literature. With judicial decisions, it's very similar. That means that in Slovakia, I have to say that we have a quite long history of electronic publishing of judicial decisions. So in Slovakia, more than 20 years ago, we started publishing each court decisions, even the lower court decisions. So there's a long tradition there, but what has become a lot faster, easier, cheaper is the search. Again, the search used to be very hard, it used to be very slow, and to find the right decision used to be like very difficult. And now, again, Google-style search, you can look at that quite quickly. The results are relevant to your search. So this has become very useful. And again, copying of text. Yes, you can copy huge chunks of the decisions without having to retype it again. You can redraft it, etc. So that's similar like with the literature. One disadvantage, I think it's particular to Slovakia, I think other countries are well advanced in this area, is, well, Slovak law is a continental type of law. That means it's not based on formal precedent, yes? The judicial decisions are only persuasive authority, and you are not bound by a former court decision, but it's persuasive authority. You can use it, of course. But in Slovakia, it's a problem that the decisions are not interconnected. So unless you are representing a client and you know all the history of the case starting from the lower court, ending up at the higher courts, it's very tough, like, to see how the case developed. Because in Slovakia, we have 4 levels of courts. You start the district court, then it's regional court, Supreme Court, and constitutional court. And sometimes you find a decision, and you think this was the final step, and then you later find out that this decision was reversed by the Supreme Court, or by the constitutional court. And it's not just a problem for lawyers, it's also a problem for the courts themselves, because, for example, the Slovak Supreme Court is publishing major decisions in booklet each year. And sometimes it happens that some of these decisions are then reversed by the Constitutional Court. So you have a booklet of decisions, some of which don't stand, yes? So, and the problem is that even if you use this legal software for research, it's very hard to connect those decisions, because some human would have to input that information, that this case was later remanded or reversed by a higher court, because the decision itself in the metadata doesn't contain information on the lower court. Where does it start? Sometimes it happens that a case starts at the district courts, comes to the regional courts, and goes back to the district court. Yes, so there is let's say there is a trail there, but in order to have that trail, some human would have to input that information, and that's very difficult, time-consuming, expensive. So usually this legal software doesn't connect these dots. I'm well aware that in many countries this problem has been solved. For example, I'm also studying in England, and there 12 years ago already they had software which had this connection. So you can very easily see how the case started in the High Court, then went to the Court of Appeal and to the Supreme Court, and you could see the whole trail of the case. This is something we are missing in Slovakia, and it would be very nice if it could work. I mean, the problem why technology cannot be used to do this is that we don't have this data available generally. Yes, some human would input the data, and that would be expensive. But this is something which could be improved at least in Slovakia. So, and maybe one last point to the judicial decisions is that in Slovakia it's quite hard to find the so-called, we call in Latin, res judicata, or the legal sentence. Yes, because usually what the court says in the decision is that the court approves the lower court decision, or the court remands the decision to the lower court, but you don't actually see the legal sentence until you read the whole case. And in order to find the legal sentence, a human has to see it, look at it, usually a lawyer has to look at it, and highlight the legal sentence. Because I know, because this is what I do for one publishing house, that I am reading through major court decisions in the area of arbitration, and I'm sending it to the database of that publishing house, which then they publish in their like whole database. But again, there has to be some human who does it. Yes, so it's still not done by AI, and this is something which can be also improved. That to have these legal sentences, which is usually 1-2 sentences, highlighted in each case. So we don't want to know whether this case was approved or reversed. That's not so important. Important is what are the legal arguments there. So this is something also mentioned by my colleague earlier. Okay, so we can go now to the second major topic, and this is content creation. Yes. So this is something I would say rather new. So search has been gradually developing in the last 15 years, but this is something we started using maybe a year ago. So content creation using generally available AI tools. I'm not mentioning any names, so I don't want to make any promotion, but I think you know, talk about the major providers of these tools. So you just input the right name there, but again, I don't want to make any unlicensed promotion. And we started using it in areas of contract provisions, let's say drafting, and legal opinions suggestion. But what we found out, the bottom line is that it's still very weak. So even if I asked the AI tool to provide me for a simple answer to a very simple legal question, in most cases the answer was wrong. But that's not the whole problem. The problem is that the answer was wrong, and it was very convincingly wrong. The AI thought it was right, yes? So it was very convincing in telling me the wrong answer. So that is somehow problematic. So we somehow reversed the use of this software. So we come to the conclusion ourselves, and we just then use it as a fact checker, as a sparring partner. So if the result arrived by the AI is the same result as I arrived earlier, and if it's different, I try to find what is the difference, why is it thinking something else that I was thinking, and then I use it again in a Socratic method. Yes, so basically, if the AI thinks something else, I want to know why it is something else, and if the arguments it uses are relevant or not. So it's basically having a very sophisticated opponent, yes, to your legal opinion. And again, with contract drafting, you draft some, not the whole contract, but usually some contract provisions, which then can be used as a sample, which you then redraft, adapt, etc. Yes, so not the whole usual contract, but some provisions, and then you use it as a beginning, yes, which you can then improve. Very important thing mentioned in basically all the presentation is confidentiality. So what is important, I would never send any sensitive data, any personal data, any client data to such general available AI tool, because I have to work under the assumption that all data I put become public knowledge. Yes? I think there was been an issue in the past that employees have put confidential data into these AI tools, which the AI then learned this data, and this data has been then provided to some other people on the other side of the globe who retrieve the data provided by this AI. So you have to work under the assumption that what you put in becomes public knowledge. So the stuff I only put in is general legal opinions. That means I wouldn't mind if that would become published. Yes, it's a general, let's say general opinion, not connected to a particular client. And the same with contract provisions. It's one provision in a contract which is quite general, is not connected to a particular client, so I wouldn't mind if that provision became public. Yes, so this is something people need to deal with, that if you use it, I wouldn't certainly use it as a spell checker in whole contract. Yes, I put in a 100-page contract, and please spell check it. Yes, because then the contract, you have to assume, becomes public knowledge, and you don't want that to happen. So this was the second topic, and the last topic is connected with translation. Yes. Yes. This has been also gradually improving in the last 15 years, as I recall, because when I was starting as a trainee 15 years ago, a lot of my work was connected with translation of contracts, affidavits, legal opinions from one language to another, usually Slovak, German, English, and that improved a lot. I mean, these generally available, let's say, translation tools are a huge time saver. You still need to know the language. Yes, you cannot rely completely on these translations, because at least in rare languages like Slovak language, it's quite rare. Yes, and the service providers, they don't really want to put money inside Slovak language, which is not used by so many users. So in these rare languages, the output has many syntax errors, has many grammar errors. So you still need to prove the whole text, but it's a huge time saver. For example, work which would take me 15 years ago 4 hours, now takes me 1.5 hours maybe, because I already have the first draft, which I just then check, and I don't have to translate it word by word. Yes, one of the, of course, disadvantages is that it only applies to unofficial translations. In Slovakia, in many cases, we need official translations by people with a stamp, yes? And in that case, of course, you need to approach a professional translator. But otherwise, other translations which don't have to be official, that this is a very big time and money saver. Issue, the same again with confidentiality. I wouldn't send confidential, personal, sensitive data to a translation tool outside of my computer. What we start using recently is translation tools which do not leave the workstation, which don't leave the computer. So the translation is being done at your workstation and is not put online, which is also a very good like GDPR aspect of the whole stuff. So you can translate the whole contract, but it remains within your computer, so you're not worried that it goes somewhere on the cloud and becomes available later, yes, because it leaks somehow. So this is what we started using, the translation tools which don't leave the PC you're working on. Okay, and my last slide is connected to the distinction between smaller firms and bigger law firms, as I see it, yes, because I have all my professional career, I have been working in small law firms, and I have only like the information from big law firms from my colleagues. Yes, but I've never worked in a big law firm. But the way I see it, the biggest difference is that small law firms don't have access to custom-made software. Yes, basically it's too expensive for us. So big law firms what can they do? They can invest their budget into making software which is tailor-made to their needs. And it doesn't have to be general legal software. If you're an IP firm specializing in trademarks, you can just have a trademark infringement software which is used to your needs, so it doesn't have to be general. But it provides you with a comparative advantage because it's not available generally on the market, it's available just to you. Of course, you have to invest into it, but then you have an advantage. So this is something the major law firms have an advantage in that they can invest money into a tailor-made software in these areas of search, content creation, and translation. And usually, this software is a lot more, let's say, reliable than the software which is generally available. Not least because of the reason that the input which you put inside the software is just legal stuff. Yes, that it's focused on legal stuff. Other these softwares you're using, it's not usually focused just on legal things. You can use it for marketing, you can use it for other content creation. But if you just focus on legal stuff and the input is legal data, nothing else, then the results are a lot more reliable than the result you get from general, let's say software. So these were my, my perceptions from a small firm view, and I'll be very glad to answer any of the questions. Thank you very much.
Maybe actually we could turn some other mics on as well. That makes it slightly more efficient instead of us all passing the mic. But no, hey, we learn as we go. Again, Pavel, that a wonderful story. And actually, maybe starting with you, I think it's always like a David and Goliath story for the smaller firms. But when you think about it, right? So what feature point should be really then addressed or accessible specifically? So you're really containing this, but now turn it into a feature that you would see as a small firm, as this David firm. How could I use all of this to empower myself against the larger ones?
I would just tell general answer is that I perceive that the gap between smaller and larger law firms in many areas is becoming thinner based on this software, that you have access to a lot more data a lot quicker, something which not used to be the case 15 years ago. And I just think that any of these tools which you use makes let's say, English called level playing field. Yes. So basically, if you can use this software, you can, the advantage which the higher big law firms have, you can make it smaller. Yes. So you can represent cases where there are a lot of information, a lot of data, and if you have this software, you can chunk the information to a smaller bits, and basically don't need 10 trainees to do the work. So this is, I think that any of the software you're using, other translation, content creation, search, etc. So can be used in order for you to be able to compete to a certain degree with higher law firms, and not compete with respect to clients maybe, because usually bigger clients always go to big law firms, but maybe with respect if you have a lawsuit, for example, or a contract drafting or contract negotiation, then the both parties, let's say, are equally well represented. Yes, so I'm be able to sift through hundreds of pages in a very similar way than 10 trainees would do. Yes, and in that case, if you have a contract negotiation between a small client and a big bank, then the result becomes similar, although I don't have 10 trainees available to go through all the documents. Yes, so I think that any of the software you use, it helps small law firms to be able to provide services to usually smaller clients on the level which is comparable to the result of the client.
Hey, you were also the one that actually brought up GDPR. I think all of us mentioned confidentiality and privacy. I think that came loud and clear also through the questions. And maybe that is a question I want to shift a bit to Radu first. Are we doing enough there? Are we being reactive, or should we be more preemptive in terms of regulations in this front?
Thank you for the question, Roger. We should be preemptive, but in fact, all of us know that the law, legislation in itself, it's always reactive. It's always behind the life that puts in motion everything. So law always adapts. But now I really believe that we have somehow a glimpse on the future, and we can understand that we should be preemptive. For instance, I really believe that the law that we have in this moment, it's not a law, it's basically a recommendation adopted by EU Commission, is the EU AI Act, which basically recommends for every state to react and have national legislation in order to legislate AI, artificial intelligence. For instance, I was very surprised to see on the news that on 9 October, Ukraine, which is a nation at war, is starting to legiferate basically the use of AI. So we are not at war. guys. So we should do the same. We should do better than them. We should do it faster. We have in this moment, we have the directives. Let's work on that.
And Bogdan, would you want to care from your point of view actually on what Radu said? So what is your take from that, from your perspective specifically on this? Are we doing enough? Again, should we be much more proactive? And how do we do this? So how do we regulate something that we don't know where it's going to go?
We should continue, but probably not as fast as we could do it. I mentioned earlier what happened when things got very, very quick. For me, it's an experience. So I think that today we should be more careful about the speed that we are using. Yes, thank you. When we legislate digitalization, just because the power of human nature to adapt, it's sometimes less than the power of the human nature to create things. We know today that a normal human being needs about 30 days to install a new habit. We should take that in consideration. Some will tell me, well, probably, but what we do with the problems that we have to solve? Delegate. Delegate to the artificial intelligence. Automate. And keep the focus on that side of the human nature, which is yet not very developed, I would say. Again, the emotional side, spiritual side. For me, it's a very interesting metaphor, the movie Interstellar, with all the dimensions evoked there. I think we are in the same path, and I think we are right now on the process of integrating a new dimension. That's intuition. It's over time and what we already accumulated until now. And on the legal side, on the right side, it's about how we manage, especially us, the legal profession, how we manage to create the sense of confidence in our citizens, in ourselves, first of all. Because when we are confident, in other words, when we are feeling free to do things without being scared that we will suffer if something goes wrong, then we'll develop. And when we are confident, we develop trust. We have trust one each other. And starting there, we can work together. And there we are creating our real value. When we work together, we are creating the maximum of new value, added value that we can create. And legal profession are the most important actor on that process, because we are working with rules. We are working with habits. Rules are habits. And when we are creating habits of confidentiality, habits of trust, we have a massive impact on our survival as a species. Not only us present here in that room today. Maybe it's a too progressive opinion, too progressive point of view. That's why I'm stopping here. But I invite you to reflect on that. And I, of course, thank you very much for your attention.
No, I think, again, I think that that's an excellent point. And I think this also is just a whole point of exchanging our values and again, amongst yourself or with each of the folks here, please, reach out and have those conversations. That's why you're here. But no, thank you for that point. Shifting to you, Pavel. So maybe actually, looking at the time, I want from each of you, starting with you, Pavel, like, if you want to give the folks here something and those following on, if you want to give them something to take away, this is going to be a question for each of you guys, so you can think. I'm putting Pavel on the spot first. What would that be? Like, if you want the folks to walk out, having heard our talks and these conversations, what's the thing that you want to say, hey, I hope that they will remember this piece?
I would just sum it up in one sentence. Don't be afraid to use new software. Yes. To provide a longer answer, we are doing many seminars on electronic signature, GDPR, etc. And I'm dealing mostly with all the lawyers than I am. And I'm saying they're usually afraid, and they are all, many times they are citing Detective David Murtaugh from the Legal Weapon movies. I don't know if you know them, but he always mentioned this sentence that I'm too old for this stuff. Yes. And
good paraphrasing.
Yes, and this is what all the lawyers are saying. I'm too old for this stuff. And I say, you're not too old. I mean, we are using 4 different softwares for legal signature, 6 different softwares for communicating online, 4 different softwares for legal search, which I have not been using 5 years ago. Yeah. So it's the same for everyone. I mean, the software is new for everyone. And usually you just have to try it and work with it. And you can, in a few weeks, you'll be a professional with it. So to sum it up in one sentence, again, don't be afraid to use it. Everyone is a beginner at the beginning. So, and you're not too old for doing it.
Excellent, thank you. Next, well done.
The takeaways, 3 things. Where we are, where we want to go, how we're going to do it. Where we are in the point where the projects we are talking about until yesterday are real actions today. We see the tools, we see improvements, we talk about that. And the most important thing, they are institutional actors which are acting today. Besides the National Union of Bar Associations, there is at least another one public agency which just announced in a private event that they will launch in a few days their new platform, which contains a very, very innovative module dedicated to the work machine to machine. In other words, governmental agency will start to work machine to machine. It will be in a few days. The event, it was private. I've been asked to respect that, so I'm doing it. But I can assure you, the government starts to align to the possibility existing today. Where we want to go, I said before, maybe in a too audacious way. How we do it? By turning to ourselves, by paying attention, by allowing ourselves to acknowledge more about how we are as human beings, how we function, and using that way of function to integrate those new tools which allows us to massively compress the time to accomplish day-by-day tasks. 3 things.
No,
Thank you.
Very articulative, thank you. Radu.
I'll be very short.
Very, very short.
So I will continue his idea. Do not be afraid to use it, but just like everything else in the life, you have to use it in order not to control it. That's all.
Trust but verify. I think that's a very good point. Get out of your comfort zone, which I think saw a lot of this here as well. But be diligent, right? I think that's really. I think you nailed it in your very short sentence. Thank you. Last but not least, Magda.
Yeah, actually, my colleague stole the one I wanted to say, because I wanted to say be aware what you are doing also. Not be afraid of using AI or generative AI, but be aware how you are using it and how it works. But also the other thing, for me, which is very important, that we need to understand if we expect more from technology, we need to change our habits. So from keyword search, also which were mentioned by Pavel, we need to learn how to prompt correctly. And those are things also to learn for us as lawyers, how to change our habits. It will take a bit, 30 days, correct, to change habits. But if we expect more, we need to provide more.
That's again a very, very good answer, and thank you very much, everyone here, and same for you guys all listening as well, but also here. Thank you. This was, I think, our first panel, so thank you very much, guys.
Thank you very much. We now invite you for a short coffee break, and if you can please join us again in 20 minutes. Hopefully we will fix the glitches with the screen and things will be much smoother. Thank you very much. Should we stay for a photo? Sure. Actually you, because you have the panel. So if you want
Hai, Dominic, du-te, Dominic, hai, băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai, mă, Dominic, bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cel mai bun din tine, hai. Hai, bine, bă, Patrick.
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Bun, dacă ne-am înțeles, atunci hai să semnăm. Bine, ok, te pup, pa, 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 pa.
Cu CertSign câștigi flexibilitate și siguranță.
Dacă am fi fost o cofetărie, de ziua noastră ți-am fi oferit tort și multe prăjituri. Dar pentru că suntem Brico, sărbătorim 20 de ani cu o tonă de oferte. Hai să le prinzi pe toate în magazine și pe bricodepo.ro.
Brico, brico, brico.
CertSign câștigi mobilitate și dinamism.
Și tu vrei să obții 100% online semnătura electronică calificată pentru SPV? Dacă de acum trebuie să depui exclusiv electronic documentele la ANAF, atunci de ce să nu obții și semnătura electronică necesară tot online? Achiziționezi 100% online certificatul calificat de semnătură electronică CertSign prin identificare video la distanță, echivalentă cu prezența fizică. Alege semnătura electronică calificată CertSign care ți se potrivește, pe token sau în cloud, cu valabilitate de 1, 2 sau 3 ani. Află mai multe pe certsign.ro.
Hai, Dominic, du-te, Dominic, hai, băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai, mă, Dominic. Bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cel mai bun din tine, hai. Hai, bine, bă, Patrick.
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Bun, dacă ne-am înțeles, atunci hai să semnăm. Bine, ok, te pup, pa, 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 pa.
Cu CertSign câștigi flexibilitate și siguranță.
Dacă am fi fost o cofetărie, de ziua noastră ți-am fi oferit tort și multe prăjituri. Dar pentru că suntem Brico, sărbătorim 20 de ani cu o tonă de oferte. Hai să le prinzi pe toate în magazine și pe bricodepo.ro.
Brico, brico, brico.
CertSign câștigi mobilitate și dinamism.
Și tu vrei să obții 100% online semnătura electronică calificată pentru SPV? Dacă de acum trebuie să depui exclusiv electronic documentele la ANAF, atunci de ce să nu obții și semnătura electronică necesară tot online? Achiziționezi 100% online certificatul calificat de semnătură electronică CertSign prin identificare video la distanță, echivalentă cu prezența fizică. Alege semnătura electronică calificată CertSign care ți se potrivește, pe token sau în cloud, cu valabilitate de 1, 2 sau 3 ani. Află mai multe pe certsign.ro.
Hai, Dominic, du-te, Dominic, hai băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai, mă, Dominic, bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cel mai bun din tine, hai. Hai, bine, bă, Patrick.
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Bun, dacă ne-am înțeles, atunci hai să semnăm. Bine, ok, te pup, pa, 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 pa.
Cu CertSign câștigi flexibilitate și siguranță.
Dacă am fi fost o cofetărie, de ziua noastră ți-am fi oferit tort și multe prăjituri. Dar pentru că suntem Brico, sărbătorim 20 de ani cu o tonă de oferte. Hai să le prinzi pe toate în magazine și pe bricodepo.ro.
Brico, brico, brico.
CertSign câștigi mobilitate și dinamism.
Și tu vrei să obții 100% online semnătura electronică calificată pentru SPV? Dacă de acum trebuie să depui exclusiv electronic documentele la ANAF, atunci de ce să nu obții și semnătura electronică necesară tot online? Achiziționezi 100% online certificatul calificat de semnătură electronică CertSign prin identificare video la distanță, echivalentă cu prezența fizică. Alege semnătura electronică calificată CertSign care ți se potrivește, pe token sau în cloud, cu valabilitate de 1, 2 sau 3 ani. Află mai multe pe certsign.ro.
Welcome back to the fourth edition of Legal Innovation Day. For the second panel, we've asked Peter Becks, Vice President of Global Product Management at Wolters Kluwer, to join us and share with us his vision on the product management software. Actually, a very, very important tool which is starting to get to be used by many, many lawyers, because beside the legal research software, which is the basis for any professional, then the process management software helps you efficientize your activity. And this is becoming more and more important with all these new requirements of do more with less. Everybody feels, I think, that pressure. Mr. Peter Bax is a seasoned executive in professional information software with over 25 years of experience and focus on product development. Actually, the projects he's handled now include the latest generative AI technology to enhance the legal research databases and software. And Peter is based in Netherlands, and he's doing a great job for Wolters-Kluwer. Thank you for being with us. AI-driven contract lifecycle management. Well,
yeah,
that's a tough one.
Thank you, Adrian. I'll do my best. First, I would like to tell you a little story. A couple of days ago, I met with a large corporation, also headquartered in Amsterdam, actually in the Netherlands, with about 75,000 employees and about 300 legal professionals in their legal team. And I had a good meeting with the person who's responsible for legal operations and outside counsel management. And at a certain point, of course, we also talked about technology, etc., and whether he expected that would change anything. And he said, well, yeah, the main thing I expected will change, and that already started, he said, is that we expect to do more ourselves because technology enables us to do more ourselves. I thought that was actually interesting because corporations, often starting with the larger corporations, are of course the major customers of the law firms, and then it's also important for any lawyer to understand how customers are actually looking at technology and how they aim to implement technology. So that's why I today in my talk will focus completely on technology at the corporate legal department, and that then of course has an effect on the technology and also the collaboration between the legal departments and the law firms. So with that, let me start with a very full slide. That's this one. Don't worry, you don't have to read this. The whole purpose of this slide is to show that when you look at the workflow of a corporate counsel, a legal department, you see different steps, and you also see different point solutions, many different point solutions. This is only a selection. And you see that they are also very isolated. So it's not easy, actually, for a corporate legal department to determine where to focus and what solution to choose. And that's also why you see that many of those corporate legal departments take a step back and say, we probably better make a solid digital strategy first before we start entering in too much of the point solutions. And earlier this year, we did a research together with the European Legal Tech Association to ask the corporate legal departments, do you already have a legal digital strategy for your department? And what you see here is a number of 44%. That 44% basically means that 44% of the respondents said, no, we don't have one yet, or we are working on it. So that means that one could say roughly half of it has a solid digital strategy in their own view. And if you then dig a little bit deeper, you see that here at the right-hand side, and see, okay, where does the digital strategy then focus on? There you can clearly see that it's very much around contract management and document management. Not surprising at all, of course, it's not surprising at all. But it's important because then if you realize that about half of the firms do have their digital strategy in place, that they focus on contract management, and it of course also does make sense to focus my presentation on contract management for corporate counsels. So the following slides will be completely about contract management at corporate legal departments. What you see is that the corporate legal departments have get very used to the basics of technology. Everybody is using shared documents and collaborates in databases. But you also see that there is a expectation to move up to the value chain. So not the basics anymore, but focusing on collaboration and focusing on workflow automation. Whatever that means, well, collaboration is probably easy to see because then you can look at collaboration internally and definitely also collaboration between the legal counsel and the lawyer. We also see that contract lifecycle management really fits in this. They say, okay, if we want to have more professional contract lifecycle management, then we have to move up that chain. With the basic technology, it will not work. So then you can say, okay, contract lifecycle management, but to really understand it and to really see as a corporate legal, you also have to understand how does my process then look like and what are the most important steps in that process and where are the most pressing pain points. This is just an example, but you will probably all recognize it. If you start with intake and then you create documents, documents have to be reviewed, they have to be negotiated, then you finalize them and you store them. It's kind of a typical, the typical flow. What you see is that so far, much of the digital technology has focused on the storage. One could say, yeah, okay, that's helpful because then we at least have a database. At the other hand, it's also a little bit strange because then you start at the end, you say, okay, everything has been done, now I store it. But that's what I mean with the basics of the technology. Yeah? The basics of the technology are in place. But now it, of course, gets interesting. And then you get a, hopefully, let me see if that works. No, I would like to go to the next slide, but that, there, I think now it works again, right? No, okay. Now I'm looking at the technology, friends, but it's not moving anymore. Now it's moving too fast. Oh, there you go, that's good, thanks. This is good, because what I wanted to show here is that there are many touch points in this whole process where you can start your digital strategy, where you can start automating. You can start all the way at the start with automated contract intake. You can also look at AI-driven contract generation, as we already also discussed in the previous panel. Not everything is at the same level of complexity, and not all are at the same level of pain points. So what I think the corporate legal departments will now tend to do, and we see that already in practice when we talk to our customers, is that they say, okay, I cannot do everything all at once, so I have to focus. I understand that it's helpful to have everything in one database. So the storage they are all inclined to start working with, and that of course already helps. One thing that comes with storage is consistency of your data. That basically means that you have to have your contracts in a specific format and that you have to metadata them in a specific format to make them really useful. So what we see happening is that many of the legal departments really start working from the end, going step by step, going upwards the chain, and say, okay, if I then have contracts which I want to store, I have to make sure that I have my contracts consistently made. Okay, but then I have to make sure that all the lawyers in my, or all the legal professionals in my team actually work in the same way, which is already a challenge, especially if you have legal teams divided around the globe. So you see that making things consistent is then already a big challenge. And then they start working up the chain, and at a certain point you come to the more advanced technologies of creating those documents. I've just shown you a whole list of things that corporate counsels can choose from. In this same study, it was also asked, okay, what do you then look at first? And they said, yeah, first of all, I'll look at return on investment. So yeah, okay, that's actually clever, because if you spend money, you also want to have some return. So one could also say, yeah, that's politically correct to say that. But it's not easy, because then you say, okay, return on investment, how do you actually calculate that? And then what we discovered is that the numbers start counting, because then they say, okay, return on investment means how much time can I save in my department multiplied by the number of times I have to do this. I took this example of contract review. Because we see that a lot of time, of course, is spent on contract review. Just as an example, we have a product that's called Legisway, which is one of those storage databases, right? And in that storage database, we have about 160,000 contracts. Assume we would like to review them, and let's take 40 minutes per contract for a professional to review a contract, which is already fast, I think, but okay. That would mean that you would need about 51 years to do that manually. So that is already a first sign that they say, okay, if we want to do contract review more efficiently, you will need to use more advanced technology, and that's where AI comes in. And what we have seen so far is that much of the AI, which by now we then call kind of traditional analytical AI, has focused on this contract review. Because if you say, okay, we've done the first step, we now all have it in one database, and as a legal department, I have my house on order, and we all work in the same way, so we have consistent contracts, then the first thing you can do is actually analyze those contracts. You're not even making them, you're not negotiating them automatically, it's just a review. Review can actually be done by AI. There are several solutions in the market that do nothing else than help the legal department to review their contracts based on very specific questions. So, for example, what are the terms of termination? What is the termination date? All those kind of things can be done now rather easily, as long as you have your contract stored consistently again. So then we can say, okay, we now have a database, we have stored everything, we can review it with traditional AI. I'm actually in a good spot. And then generative AI comes around the corner and say, yeah, you can do much more. Because remember, if you remember the workflow, we are still at the bottom of the workflow, right? Storing, reviewing. We're not negotiating, we're not making any contracts yet. With generative AI, the promise, of course, is, but you can make contracts. And then the question is, how do we now do that? And that's what I want to show here. There are a couple of options. I'm sure some of you already started doing this. Can I actually write legal paragraphs or legal contracts with generative AI? Can I use GPT to do that? And one can say, actually, we've also done it, and one can conclude, yes, you can do that. It's not always right. Definitely a human has to review it, but as a basis for inspiration, generative AI, as it has been launched recently, can be used for contract generation. So one could say, okay, let's just do that and let's try to implement it and let's try to roll it out. There are, however, two main problems. The first problem is that the language models, for example, GPT, are trained very widely. We've already seen that earlier this morning. About 4% of GPT is trained on legal data. So you will get a lot of waste. That's one thing. And the second thing, which we have not touched today at all, but which is very important, is that those large language models will be expensive. They are expensive to make. They are made by only a few companies, the big ones, Microsoft, Google, Amazon. And for one thing we know for sure is that they want to make money on them. If possible, a lot of money. So they will not be cheap in the future. That's our expectation. So that is why we already think that at this stage, we have to look at alternatives. And what I personally find is very interesting is that if you look at the more targeted language models, so that does not have to be large language models, but targeted language models, you see that you can do very specific tasks with very specific language models. And that's what we've called here the screwdriver versus complete toolkit approach. The complete toolkit is, of course, then GPT, which can do everything. And the screwdriver is only to drive the screw. And we believe that, in general, we will move towards a situation where the screwdrivers will be used to do those very specific tasks, due to the two reasons I've just given to you. The others are very broad and will eventually be very expensive. And on that last note, the costs, we have done some experiments with GPT in our company, and what we see is that it's not so much the number of times you use it, but the number of tokens you give to the large language model. And the number of tokens is driven by the size of the document. The big disadvantage of legal agreements is they are often large. Yeah, you all do that. You are lawyers, you make large contracts. And large contracts are hard to handle. That means that especially contract review and contract generation with generic AI will be expensive. And that's why I believe that it might be helpful to start looking at other more specialized large language models. And I took this example. This is from an experiment we did ourselves recently. We have a language model in-house. We already have that for a long time. It's not a large language model. It's a small language model, actually, and it has been made to analyze contracts, and we've now tried to see, can we now also use that to generate contracts? And you see that it's possible, but it can only do that. So it can only focus on making specific paragraphs of specific types of documents. The advantage is that, okay, it does a very specific task, but for me the biggest advantage is that it's a language model which is 10,000 times smaller than GPT. And this will make a difference in the end, I personally believe. So what I personally believe it will happen is that more and more will we see very specialized language models, either built on open source possibilities or of a specific version of the larger ones, that can do one specific task, but only that very specific task, and then put them in series. So, for example, if you were to say, a very easy example, if you would say, okay, I have to make a contract consisting of 5 paragraphs, but each paragraph, of course, says something different. One could think that you say, okay, we have 5 different language models put in series, and language model 1 can do paragraph 1 very well, and so forth. We already see that happening. I'm not sure if you've all seen Harvey, which is a product based on GPT. That's exactly what they do. I met with them last week and I said, okay, how does it then more or less work? Yeah, they don't tell everything, but they said, well, one very important thing is that we use small language models, very specialized language models, and put them in series. That's how it, I think, will eventually evolve. So, rounding off, just a practical example on how that then could work. Contract playbooks are a very familiar phenomenon in the legal world, of course. That basically tells you, okay, this is how contracts in our company have to look like. This is what every paragraph has to say. If you then look at how that current process now works, if you get a contract from a supplier here, I used the example of a software provider, and say, okay, I get a contract proposal, and the legal team looks at the contract proposal and compares that with the playbook, right? That's what happens. They say, okay, is this all in order with our playbook? A lawyer goes through that and says, yeah, here and here we have to change, so we have to renegotiate, we have to amend, we get a new contract. At a certain point, say, okay, this is good, now we can sign it. That's how it now works. What AI could do for those contracts is that we say, okay, we first of all, as a preparation, you see that at the top, we have the legal team loading sample contracts and the playbook in a system. And then the contract which we get as a proposal from the software provider is then used as, or is then also uploaded in that system, and then the algorithms make the comparison. They start to match the different texts and say, okay, here we have an abnormality. This is actually different than what we would expect, and then that pulls it out. So you can actually very easily say, okay, this contract is for 99% okay, but those and those paragraphs are not okay with our playbook. So you see, the only thing that the AI does here is match paragraphs with each other, legal text. You show one legal text with another legal text, you match them together and say, is there an abnormality? That's the only thing it can do. But that's also the only thing you ask from it, right? If you very specifically say, I want to have a playbook analyzer that can only compare contracts with my playbook. That's it. Then you can make very specific AI, and then you can also make sure that that AI does the job, and you can also afford it. That, in general, sums up my story. I know that we do Q&A at the end, so I think that I want to ask you to do the introduction, Serien.
If there are no questions from the audience, I will have a question for sure.
Sure.
But I think we have a question from the audience.
Oh yeah, even better.
No. Should work. Hello.
Thank you. I'm Christina from BRD. Do you have a solution for addenda?
Oh.
What? Well, here, this should work better, I hope.
We'll try again.
All right.
Okay, yeah.
So when we amend the contract and we have to create another document that is amending the contract, we have a solution for that so that we can generate automatically and have the possibility to see very clearly what has been changed, what I mean, I'm not talking about the negotiation part.
No, it's really the redlining, I guess, that you said this is different.
After signing,
we
have to modify, and then, well, we have trouble, you know, just keeping track with everything, and do you have that solution?
Truck changes.
Sorry?
Truck changes?
Yeah, exactly.
No,
that's but it's...
No, it's not track changes. Because that is when the negotiation part takes place.
Yeah, I understand.
But then we sign the document, and then we have to make an addendum.
Right. I understand. Is that already in the software as we have it here in Romania, actually, Adrian?
No, but the question is, they want to check that against what it was sent.
No. Well, so let's say specifically, you want to modify. Okay, you make the track changes, but then you want that all the amendments that we made, be translated into clauses in an addendum. And
So she wants to have a standard contract, and then everything which is changed and agreed upon to generate an annex saying from the standard contract you will have that.
Okay. Yeah, I understand the use case, but I've not seen a solution for that yet, because then you mean that should then be automated, right? And not done by a human, but as kind of an automated process. I've not seen that yet. So I don't think it exists, but if anybody is aware of it. Yeah, it should exist. That's clear. Yeah.
Because the life of a contract is also the addenda.
True. Yeah, you're absolutely right. It's,
all right.
So I think it's a clear example of where in the process is automated is needed or can be used.
It is very needed.
Yeah. Okay.
Most of the contracts that we have are modified after they are renewed. Clauses are changed and everything.
Understood.
And we have generator for contracts, new contracts. This is very easy. Just have a template and
you can do template,
just, you know. But then when we have to modify and keep track and do it faster, because when we have to modify, we have to look for the clauses, and
then put on paper what
Right.
we modified, just make references to the initial clauses
Yeah.
and yeah.
Okay, okay. Yeah, I think it's a very clear use case. I don't have a solution for it yet,
Alright.
but we will take it on board because this is a very clear one. Eh?
Yeah, thank you.
Okay,
Thank you.
no, thank you.
It's definitely another type of corporate legal management need
Mhm.
that needs to be covered,
Mhm.
of course. Then, anyhow, are there any other processes in legal departments which can benefit out of the generative AI? So besides the
Mhm,
contract
mhm.
life cycle management?
Yes, I'm sure, but I think that the main benefit, you might remember that very first slide with all those different point solutions. I think that the main benefit eventually will come by tying the things together. And that does not mean that it all has to be done in one solution, but with the API technology as we currently have it, I think that we can make huge steps forward. So it's not so much one process that we can improve eventually, but by tying them together, you can improve the whole process.
Thank you very much.
Welcome.
I think it was a great informational, and we still have to find a solution to generate these changes. So, as we said in the beginning statement, we are actually want to present actual AIs which are working and used by the best professionals. This is why we want to see in this panel only in-action activity, and for sure we will see. I would like to invite Mr. Cosmin Răzvan Mihailă, judge, and the president of the Court of Galați, Court of Appeal Galați. Actually, under his leadership, the Court of Galați has digitalized and has implemented many AI tools which are actually live and used. And because of this successful pilot project, let's say, it was not quite a pilot because you have a lot of instances under the Court of Appeal. So right now it is functioning countrywide in all the courts in Romania. So he is a real legal tech enthusiast, I can tell you that for sure. Also, I would like to invite on the scene Mr. Andres Vara. He is also an attorney, but what can I say is for the last 20 years he held positions in the governing bodies of the Bar Association in Poland. He has just ended a mandate for being a dean of the equivalent of our UNBR, so the National Union of Lawyers from Poland, where he succeeded in implementing, so not only wishing for, but implementing some digital solutions. I think you'll hear more about in the presentation. Of course, he's also an editor and co-author on different publications, but I will let him speak afterwards. Also, I would like to invite Mr. Petroniu Secăreanu, General Manager of Canon Romania, which has over 20 years of experience. And for sure we'll see some live action from paper to action, actually. So we know that paper is still one of the nice things, you know, this is analog, of course, it's still paper, and I enjoy it, feel it, and okay, that's my age, unfortunately. But he's very focused on deploying B2B solutions from Canon, and you'll see a combination of 3 partners, Canon, Thailand, and Wolters Kluwer. Also, I would like to invite today Mr. Constantin Burdun, Deputy CEO of CertSign. He's an experienced Deputy CEO with knowledge of cryptography and holding a PhD in computer science. Thank you for being today. And at last but not least, Mr. Dragoș Ghiță, Head of Digital CITR. Actually, what they were doing was not talking about digitalization, but implementing it inside the very heavy workflow related activity that they are handling. He has joined CITR 6 years ago, and he holds a master's degree in law from the University of Bucharest. Mr. Bax, you have the floor, so please.
Yes, thanks. Well, yeah, I'll give the microphone straight away to Cosmin.
Thank you very much. Thank you very much for the invitation. It's an honor for me to be here. I would like to present before you our robots, our AI application that we developed in-house at the Court of Appeal of Galați in Romania. We did it as a sort of a grassroots movement to further and to implement the much needed and much wanted digitalization in the activity of the courts in Romania. Initially, it was done by just 1 or 2 programmers with very low hardware capabilities. We didn't have very powerful computers where we could run our AI models and essentially the software in production, in inference mode. We used the Google free software and the Google Colab and free offerings to, we did it open source with minimal money investment.
Okay.
Sorry?
Okay.
It's not working.
You are at 23 right now.
Yes, sir.
Aici, hai, lasă așa. Gata. Nu se vede la voi? Se vede?
Maybe it's off.
Gata. Nu se schimbă la voi? Gata. Wait, nu se schimbă la voi.
So it's stuck.
Ba da, s-a schimbat. Ce? Nu mai faci zoom sau ceva?
Okay.
Teams-ul?
Okay.
Okay. Deci.
So our application consists of a central module, and it has several auxiliary modules called robots. The central module is the heart and mind of the software. The main idea behind this software is that the purpose of it is it's helping the clerks in the registry and archive scan and upload documents submitted by the parties or received through other means by the courts. The robot sorts, processes them, and automatically uploads them to the court's database, creating the corresponding entry. Actually, it's not the court's database, but content document management system web application called ECRIS. ECRIS means Electronic Court Record Information System, which is a system which stands also behind the electronic case file in Romania. The whole idea of this application started when the electronic case file was introduced in our courts, and there was a need for many clerks to be hired in order to do the strenuous and boring and repetitive job of scanning all the documents that were sent by the parties in court. So we tried to find a way, a mean by which the robot and an AI application could read these documents, extract relevant data, and upload them to the right case file without too much, or if possible, without any human interventions, and at least for structured or semi-structured documents, I think we have achieved this objective. So in every court, the robots replace the work of at least 2 or 3 employees. In smaller courts, maybe just 1 employee, but for example, in our Court of Appeal, or in County Court of Galați, which is the City Court of Galați, the first instance Court of Galați, maybe 3 or even 4 employees can be assigned to other more important duties or less repetitive or duties which
require more work and more brain processing power than just scanning documents. The application is now used by all courts in Romania. There are 16 copies installed in all the 16 courts of appeal. It processes over 2 million documents per month, and we'd like to believe, we think it's quite a mature application. It has been error-free for at least 2 years, and it receives from us regular updates. The application integrates an image processing neural network based on the latest models in the field, on the latest models then in 2019 when it was developed. The neural network classifies between several types of documents, summonses, proofs of delivery of documents, proofs of publication of documents in the insolvency bulletin, and other documents, and delivers them to the correct robot for processing. The citațiile, dovezile de citare, the proofs of delivery, the summonses are the most numerous documents that are received usually by court. They may not be the most important ones, of course, but they represent half of all documents received every day by a normal court, by an ordinary court. And it takes a lot of manpower to scan them all and upload them to the corresponding entry, to the corresponding case file in the web app that we use to manage all the internal load of the court. The 64-bit application is written in C#, was initially developed as an UiPath robot. It lived then and it lives now on a Windows virtual machine. We used UiPath, if you know the UiPath, and uses .NET similar to C#. We no longer use UiPath. We have found it's a bit of an overkill for us. There's too much resources wasted for too little advantage brought to us, but just for our application. We think that UiPath is quite a useful tool, but for us it was better and have obtained much more benefits and advantages when we have written the application directly in a programming language. The image processing part, the optical character recognition and the neural network stuff is done on a Linux virtual machine, like everybody does, using a massively parallel pipeline of shell script, Python, OpenCV, and TensorFlow, which are programming languages and libraries used by, and the image processing libraries, which are familiar to probably every data scientist or IT specialist that works in the AI field. The neural network The neural network model used is called EfficientNet. It was launched by Google in 2019, and it was state-of-the-art then. We use it because we do not have very powerful hardware resources, so we just, EfficientNet, like the name says, it's very efficient, and we use the smallest model available, which is called P0, which has around 6, maybe 7 million trainable parameters, which is not really very much. It's maybe a couple of hundred, many orders of magnitude smaller than ChatGPT and the models that Mr. Bugs has spoken to us about. We call it CheatNet, which is, cheat comes from citation, from subpoena, from summons, and we did it by fine-tuning the original EfficientNet model on a training data set of almost 40,000 court documents. Initially, we used the Google Colab free offering and the processing power available there, the video cards, the GPU, but also the specialized chips, silicon TPU, TensorFlow processing unit. And now we have a GPU server by our court, which we use to fine-tune further the neural network. It sits on a Linux virtual machine as a microservice, as a HTTP server, which is called by all the robots when files are sent to it for classification. Unfortunately, it classifies only 3 classes until now. We are working on furthering the number of classes, but we are proud that it has almost 100% accuracy. We intend to expand it to more classes, to more types of documents which can recognize, but the model it's using is just it's an image recognition model. It doesn't understand text. If we want to classify further complicated documents, we have to understand what's written there. We can just look at them. We have to read them. So we need to process language, and we do that. We intended to do that using the BERT family of neural network models. But nowadays we have LoRa from Facebook, even ChatGPT. ChatGPT costs, LoRa is cheaper, almost free, but ChatGPT is a bit expensive. You have to generally pay for the tokens that you use. It's the Windows application. The brain of it is a multi-threaded application with interfacing in this presentation foundation that manages the activity of the robots, each robot operating in parallel on its own thread. The application and robots update themselves without user intervention if they detect a new version uploaded by the developer to Dropbox. Okay. One of the robots is called Robot Documents, RobotDoc, that it uploads documents scanned by users, by our employees, from clerks from the archives, from the registry, or other court clerks, directly into the court secret system, and from here to the electronic case file. It's easy to use for the employees. They don't have to be trained much. That was one of our main objectives, because it's used by thousands, if not tens of thousands of people across the country. And if it's too complicated, people will have a tendency to not use it or to resist it, and the costs of training them, of implementing them, will probably be higher. So we try to make it very useful, very easy to use, and hopefully useful for our future users, for the employees of the courts. The robot takes into account the maximum file size allowed by the content document management system of the courts. If the file is larger, it splits it into chunks and uploads it in the same entry, which if you have tried to split a PDF file by size, it's a kind of quite cumbersome thing to do, but we managed to do it after a lot of effort. And it's important to think that we have some limitation, but not from limitations, but not from a technological point of view, but a legal point of view, or maybe let's say an administrative point of view, because the IT department of the Ministry of Justice that oversees us, and which helped us more, at least did not oppose our effort and our project, does not allow us to write directly the files and the data to the database behind this web application, probably because databases usually are not logged. So you have to do it through the interface, much like, so we have found a library, a software tool that allows us to just to add documents via the browser in the ECRIS web application, and I'll show you how it's done. It's like a person clicking, but very, very fast. And just clicking the buttons and clicking upload file and entering there the file and uploading the file. It's very interesting, and I'd like to ask the IT department if possibly could run the video called the Interfața Roboți.
So it's going online, but
so you can see in the lower part of the video, you have the interface of the application, and right there in the main window, it's playing or it's stopped? Ah, it's just for me it's playing.
Nu, asta e. Da. Și închide-l pe ăsta. Wirecast, închis wirecast-ul. Și cum ești acolo? Dar mie că tu nu vezi. Unde este video-ul? Ups. Deci când ai apăsat cu degetul pe mine, l-ai închis. Technical issues, of course. Dar nu se vede nimica. I'm sorry, no codecs available. Okay. But it's only online. Okay. No codecs available. Sorry for the last minute changes.
Can we please put the slides on this TV too, please?
Slides. Again.
Okay, so no video. It's a pity because it's quite interesting to see how it's clicking very fast on the web page and inserting the information there. Okay. I've changed the slide and here it's not updating.
Okay, it's okay now?
No, it's not okay.
Iar nu mai easy to use. Ce? Video, it's always a problem. S-a blocat ăsta? Da. Ce înseamnă că s-a blocat? Ce înseamnă că s-a blocat? Așa și mai pot să schimb? Mă vrea? Mă vrea. Și ce vrei tu ăsta?
Okay, so we're back online. The second part, the second module called Robot Citații, is a module that automatically divides the stack of semi-structured documents that arrives each day at the court by post or by other means into individual documents, identifies the case file number for each document, creates the corresponding entry in the web app for that document in our system, and uploads the scanned document to the created entry. It's very, very helpful for the clerks in the registry and in the archive because the whole scanning procedures of at least 400 documents that arrive, 400 of this type of documents that arrive at court every day is done in a couple of minutes using a high-speed scanner which scans the whole batch of documents, after which the robot can be left to work on its own, to split the batch in the individual documents, process them, read the case file there, and upload the document in the content document management system. At our Court of Appeal, the robot automatically uploads more than 250 documents of this type, and in the whole jurisdiction, which is about 14 courts, around 3,000 documents of these types per day. The clerks, the IT department is very satisfied because no effort is needed on their part to electronically process these types of documents. The robot has a success rate close to 100%, with errors generally being caused by mistakes on the part of the staff, like torn documents, documents that are for another court and cannot find the corresponding case file in our system, overlapping documents in the scanner because the scanner is high speed and ingests the document very, very fast. The robots use state-of-the-art image preprocessing technologies in Python and OpenCV for cleaning, straightening, rotating, as well as the famous Tesseract OCR optical character recognition library used by Google, which is open source and is maintained by Google and is even used in its commercial products, probably a better version than the one that is offered free for everybody. So I had an example here from the IT department. We have a proof of delivery of some sort of documents, which is about half of a normal A4 page. And as you see, it has been scanned quite rotated, okay? So you can't just send it to be transformed into text. So you have to read the case file here, maybe some other data. So you just have to unrotate it. Yes, not to straighten it, because straightening means when it's skewed, but you have to unrotate it. So how do we do that? We'll just go very fast through the steps. First of all, you invert the colors, you obtain the negative, because it's better for the next steps. Okay, so this is the original image. Okay. After you invert the colors, you used an algorithm called probabilistic half transform to identify lines in the documents, even if they are not continuous. So the red lines that you can see on the image represent those lines. The idea is that you number every line, you identify the angle to the horizontal, to the x-axis, and you just have an array of a collection of angles. The idea is that the angles most numerous, close to the same value angles in the group, the most numerous group of angles, will correspond to the text. But how do you group them? Okay. You see that the lines that are most numerous are the ones that correspond to the text. And you have to identify them and then take maybe the mean angle of them, and that is the angle that you use to rotate the document. You use another algorithm called k-means clustering, a famous algorithm that has stood the test of time, and not many algorithms in data science do, because there are always newer and better and marginally more efficient algorithms that come along. But this one is quite good. It's maybe from 1967. It's called k-means clustering. K is the number of clusters that you're doing in the data, and we use it to identify 3 clusters of closely valued angles. The first cluster corresponds to the angles of the lines of the text. The second corresponds to the vertical lines. There are not many in this document. It corresponds to the borders there. Maybe you have some sort of artifacts from scanning, which are vertical lines. And the third one corresponds to aberration, sort of like some sort of oblique lines maybe from someone that has handwritten on the document. So 3 was chosen by us because it generally falls into these types of writing. The most numerous one will correspond to the text. The mean of the cluster is called the centroid. It will be used to rotate the image using a rotation matrix. We have to pay attention because some functions are in degrees, some functions are in radians. It doesn't matter very much. We help the next step because we remove from the picture, by that we mean we replace with white lines, the most distant cluster, which corresponds to the vertical lines, so that the next step of reading the text is not bothered by the vertical lines. And then we log in our logs the angle and see the result. Let's see the result. Okay, the one over there in the right part of the image is rotated. And here is some sort of a frequency distribution of the angles, but I shouldn't probably try to histogram of the angles, but we shouldn't, I think, do it very technical, a very technical presentation. Earlier version of the robot used a program called a software program called AB Fine Reader. We no longer use it today. Why? Because it's not free. It's not open source. Our implementation, however, gives, we think, fewer errors than the version 12 of that software for our task, and is much faster, and I'll tell you why. It reaches about 134 pages processed per minute. As I said, the robot does not write directly to the database, but uses the browser itself, Chrome browser, to interact with the content document management system. The whole module lives as a Linux service. It's called the daemon Linux service. It's based on this open source library from Google and can be used by many courts to scan documents and transform them into handwritten into written text, into text separately from the robot. Compared to AB12, the error rate is the same or lower, but the speed is much higher because it makes full use of the parallelism of the processing cores, using a famous application on Linux called Parallel. That's the name of the application. So we reach the speeds in on our server of at least 130 pages per minute. The idea is that you just give a job of straightening and transforming in text to every core, in every CPU core, every core of your chip, yes. And if you have many cores, and usually the servers do, you can do it very fast. You want to scale it and do it even faster, you buy new servers and a lot more cores to the job. So it's quite interesting to see, like, maybe you have a folder with files and you just see them all, like 20 or 30 files disappearing at once, being ingested by the system and moved in another folder when they're read. It also has a logging module called Log Robot for operations performed by these robots. It's a page accessible in the browser, which is automatically customized for each instance, and which shows the key factors, the registrar or the archivist, the updated status of the operations performed. Documents that have been successfully uploaded, documents that have given errors, the type and the cause of the error, successfully uploaded documents, and proofs that have given errors. So they can intervene and solve the errors, which are very few, solve the outliers, okay? This log page can be set up to track multiple courts, so management or IT specialists in the courts can track the activity of all courts within their jurisdiction, and they do it. The page uses Ajax for quick updates with the latest information. It's a nice touch because everyone likes to have their information, the new information delivered immediately. Don't click the reload button every time. We also have a module for statistics on the use of electronic communication because we want to identify documents that have been sent by normal means, like by post, when they should have been sent electronically. And this module mainly intended for court presidents, section presidents, chief clerks, chief registrars, IT specialists, so they can take steps that this kind of errors do not repeat in the future. This has enabled the number of documents sent electronically to double from month to month in the initial phase. Now, last year, the whole year for which we have data, 1/3, 34% of the total number of documents for all the 14 courts in our jurisdiction were sent by electronic means, which I think it's quite it's the result, and it places us number one in the courts, on number one spot in the whole courts of appeal in our courts in our country.
Okay. I understand we have 1 more minute.
Okay. In testing, we have an application programming interface. We allow trusted, only in our court of appeal and our jurisdiction, trusted partners to submit documents directly to the app, to ECRIS app and the electronic case file without human intervention. Depends on trusting the partner for correct identification, classification of the document, at least until we develop our processing language models capability. Used only in our jurisdiction with a software app for lawyers and with the bar chambers of Galați and Brăila counties. They submit documents like power of attorneys for publicly appointed defenders. They choose the publicly appointed defender, they nominate him, and they send the document directly to our system. And the famous, I think, hopefully, now portal for submitting documents and paying court fees, which was developed by us, initially developed for our use in our jurisdiction, and now has been expanded nationally under the umbrella of our central governing body, at least for judicial affairs, called the Superior Council of Magistracy, Superior Council of Magistracy. And this site, this portal lives at that address, registratura.rejust.ro. Under it, it's an API developed in cooperation with the Authority for the Digitalization of Romania to allow payment of court fees, which are some sort of taxes, directly to the competent relevant mayor's office through the online hub ghișeu.ro. It has proven very popular, at least for paying court fees. In 3 months, there are already millions of our leis collected, and at least, I think now 50,000 leis per day collected in court fees, and tens of thousands of documents submitted directly to courts through the portal. So that was my presentation. If there are questions.
Thank you very much. Yeah, that's better. Thank you very much. Very helpful to see how those things work in practice in a real court. In the interest of time, I do propose that we move straight to Mrs. Wara.
Thank you for the opportunity to be a speaker. Thank you, Chairman. I represent the Polish National Bar, and I carefully listen our colleagues from Romania and Slovakia. And I want to share our experience in Poland with digital reform of the bar. 2 years ago, we started this program. This program is especially predicted for the lawyers from the small and medium-sized companies because among the 24 attorneys in Poland, 70% of them they're attorneys from the small and medium size of the legal firm. The topic. We have a topic today. Okay. The topic self-government digital reform of the Polish bar fits perfectly to introduce you to the activities of the Polish bar. Is engaged in.
It will come. They are working on it. Yeah. It will be arranged.
Okay. Could you please for the next slide? No, next one.
I dot next. Yes.
The first, we organize the several entities. The actors are involved in the program. Among them, it is Legal Tech Institute, Ethics Committee, a Committee for Education of Bar Applicants and Professional Development, Palestra Library, Product Team, and Information Technology Committee. The bar also cooperates with external actors such as Wolters Kluwer Poland. We have a very strong cooperation with this company. University of Technology, there is a department who specialize in the legal IT, and the University of Gdańsk. And this is extremely important topic that affects the effectiveness and modernity of our legal system, because we need the staff people who we are ready to success this project. And could you please? Oh, no.
Of course, technical issues happen, but
the aim of the measures we have taken is, of course, independence, security, professional secrecy, and high level of the client service, because it was the main task, because we presumed that all digital reform, the first should serve for the lawyers, and technical, how to say, aspects, for me, for example, and for my colleagues, are completely not interested. The system must be solve and reach our legal attorney task. We treat IT just a tool, not as a target in this project. Today I will focus on your key areas of this reform. The first, this is a digitalization of the bar, digital law firm, cybersecurity and communication. This is the main 4 areas of this project. Let's start with the first point, this digitalization of the bar. This is a general context in which we operate and the foundation of the reform. And activities in these fields include it's electronic attorney support system. Okay. Yeah.
Just left right. You push this one.
Which one?
You push the one. So only left.
Oh, okay.
So right, it's
right? Sorry, I am from the elder generation of Polish attorney. I am interested in ideas of this program, but technologically I am completely powerless, you know. But it's only proof that the new technologies absolutely should be fit for the guys like me, you know. This is a slide digitalization of the bar. Yeah, and this part of the project contains 3 elements. This is electronic attorney support system, communication with the judiciary, because this is absolutely the sensitive point of our job, and electronic ID card for attorney and the applicants. The next one. Okay. The electronic attorney support system is a system that will serve the process of full informatization of the bar. The system enables digital communication of attorney with the bar, the National Bar Council, and the digitalization of the judiciary. Management of the hearings. Now more than 50% of our hearing, this is on the online in Poland after the COVID. Training management, patronage, duty schedules, e-applicant, disciplinary modules, loyalty patronage with the partners. Work is currently underway to implement further modules, selection of each are the official case management module, a journal, legal representation. For example, this part make it easier for attorneys across the country to contact each other to find the legal representation. If I want to find the power attorney in another city, this program lets me to find someone to represent me in another court. Disciplinary cases, management of on-site and online training. Okay, next slide. No. Oh, okay. The communication with the judiciary. As a part of the activities in this area, a working team was formed to address communication with judiciary on matters. Two-way communication, remote online hearings without any interference, allowing secure mailbox for attorney. We need absolutely secure mailboxes, and remote access to case files. No. No? Ah, okay. Okay. Electronic ID card. This is a digital version of document issued by the district bar council. We have the 24 district bar councils, confirming attorneys' entitlements, which is the result of negotiating with the Ministry of Digitalization. It works within the public mobile application, M-Citizen. Every attorney in Poland have their ID card in mobile phone, and in future, in next few months, we want to connect this ID card with a signature. That it will be very easy for the Polish attorney to signature of the documents and show that they are entitlement to go to, I don't know, to prison, to pensionary system, to court, to administration office, everywhere. Yeah, please. Next one. Digital law firm, this is the part of the digital reform of the bars, but this part is focused on what I mentioned, the attorney from the small companies and medium-sized companies. And this is a product just for Polish attorney. A key element of this, for the digitalization process of the bar is the digitalization of individual law firms, because if we not convinced our colleagues to use the new technology, and the system will be completely out of the work. And the digital law firm represents the outcome of collaboration between the bar and Wolters Kluwer. Thanks for the Wolters Kluwer Poland, providing attorneys with the modern IT tools to streamline their work and improve the client services. Could the next slide, please? Oh, okay, good. Digital law firm is a user-friendly application that supports attorneys in their practice. This application offers tools that facilitate the management of cases, including remote access via mobile application. And the application provides the highest level of law firm data security, mobility, and free access to information, and continuity of work without the risk of image crisis or financial loss due to cyber attack or hardware failures. Okay. Digital firm enables, and this is could be interesting, case handling and management, including remote access to documents, e-signature, electronic fax, invoicing, task management, and time counter. That this application lets the attorney to manage the law firm with using only a mobile phone. And integration with other systems, including integration with the judicial portal and secure mailboxes, access to external providers. The application allows to effectively manage law firm cases from the mobile device, including archiving documents in secure cloud and quickly accessing them. This is the in my opinion, ideal solution for small and medium-sized firm. And in next sentence, I told you that this is a very cheap, not only affordable system, but very cheap. It costs only 15 zlotys. You know, espresso in Poland costs 11 zlotys. That means that we offer our attorneys for the small lawyers now the application, the system, which costs per month 1 point espresso. As this is in low. It is 16.42 euro. Yes, euro. It is 3.31. And all firm we offer our colleagues for this cost. You know that this is a very cheap. And this is the only way to convince everybody to use these new technologies because this is affordable, very simple in operating, and have improved, you know, the conscience of all attorneys, especially from the small legal firm, improve the conscience about the new technologies, about the cyber world, and so on. Moving to the third point, this is cyber security. You know, in Poland, the cyber security is a very sensitive point. I remember in 2015, the first quite big legal firm in Warsaw declared that they implement their system based on the cloud solution. And 3 days after, because of hacker attacks, all information sources from this cloud was published in darknet. You know, 3 days. The hackers needed to enter to this private, non-professional resources, and 3 days, and everybody, you know, in Poland could read everything. About the documents, about the money, all concerned was completely disclosed. And because of this, we stress on this cybersecurity, and it is important for attorney to be aware of needs to secure information and client data. It is important for us from a responsibility point of view, because we are responsible for the confidentiality. And of course, cybersecurity now, this is this space we can try to build a system who protects the data of our clients. Secure mailbox for every attorney. This is the part of this project. It is one of the most important tasks is to ensure that every attorney has a secure mailbox and to take steps to guarantee the following security measures. And now all attorneys have obligation in Poland to separation of professional and private tools. We have the mailbox, the professional mailbox, and it is absolutely not allowed to use for the private tasks like shopping, games, private communication. Absolutely private application is not allowed to put on this mailbox. Security system, data protection, and professional secrecy. Of course, the cybersecurity, this is the space which have strong impact for ethics. In Poland, we had the ethics rule from 16th, 20th century. It was a century when the lawyers used the paper and the pen, you know, and to protect the data our clients was easier than now, you know. Technology, cyber technology do that all our data are completely open for the public, in fact, and no one could guarantee us as attorney that we could really effectively protect this data. That means that we change our ethics, and now the protection of our data clients is not treated as an absolute obligation, but this is an element of the duties. If you work according to the standards and best practices, you are free from responsibility in case of hacker attacks and in case our the clients will be stolen. And the bar has also undertaken a series of action, what I mentioned, which I will list under standards and best practices. We prepare the book of the best practices, and these practices are divided on three levels. The first level is best practices for the small, very small one to attorney legal firm. The second level is this good practice for the medium size of legal firm, and the third, the worst level is for the biggest companies, legal firm, and according to the level of legal company, the level of duties is increased. If you are bigger, your obligation and duties are the higher. If you are smaller, your obligation and duties are smaller. This best practice was prepared by Legal Tech Institute, one of and the Commission of Ethics. Education. Of course, this program would not make sense without education, and we started the process of informing and educating the attorneys in Poland. The bar is undertaking the following project. We organize many conferences with the Warsaw University of Technology and University of Gdańsk on the subject of professional secrecy in online services. We cooperate steadily with the government organization like NASC, Cyber Science, ELTA, Ministry of Digitalization. Monthly series of webinars And I thanks for Wolters Kluwer, because many webinars we organize with Wolters Kluwer, who learn us as an attorney how to use these new technologies. For example, we have in Poland we use the Lex. It is a special program which is very commonly used by a Polish attorney. And paradoxically, the regular attorney use this program only in 25% because of lack of knowledge, how many possibilities, how many functionalities is developed in this product. And because of this, the Wolters Kluwer earn money because we are the good customer. But we are given from the Wolters Kluwer knowledge. Yeah, that's it. Knowledge how to effectively use these tools. Okay. The communication. Last but not least is communication, especially in the context of e-delivery. Digital communication has the potential to significantly improve the flow of information between attorneys, courts, attorneys, public administration, attorneys, and others institutions. Unfortunately, the problem in Poland is that we now have the little chaos. If we see how many systems now we have in Poland. Currently in Poland, there are several completely unrelated systems and delivery services, including electronic platform of public administration service, judicial register portal, national judicial register, national debtors register, common courts information portal, public procurement portal, and public registered electronic delivery service, and commercial qualified registered electronic delivery service. We are in period of transition. We treat this as a period of transition. There is currently confusion resulting from the existence of multiple systems. The bar is constantly monitoring. We are in dialogue and working with the state entities. And we try to simplify, unify, and organize communication, because this is the first condition. That system must be for our clients and for the attorney must be very simple. If something is not simple, this is not practical, and it creates only the problem. The self-government digital reform of the Polish bar is necessary to adapt to requirements of new technology. By implementing these changes, you are not only increasing effectiveness of attorneys' work, but also, of course, ensuring protection of our clients' data. The most slide. I like this slide. Thank you for your attention. And in the end, I look for my colleague from Romanian National Bar. Yes, you're welcome. I hope that we start to exchange our experience. I know that Romanian environment is quite different than Poland, but we are in European community. Probably the best direction is to unify the resources, solutions, ideas. That if we will have the case in Bucharest, we could feel here differently, like in Poland. You know, I wish that it could be done by our national bars. Thank you.
Thank you very much. It's very interesting, and I think also important to see how at the Bar Association the digitization is also coming through, and how you indeed, I think, very well explained that it has to be simple in order to work. So with that, I propose that we go to our next speaker.
Is it working? Yeah, great. So thank you for inviting me here. Adrian and his team, we were talking a lot about this event, and I'm happy that we can present our vision about where the organizations are going in the future, and particularly the legal organizations from a technology provider point of view. Adrian was presenting my presentation, the name of our presentation, as Paper to Action, which is quite interesting because we talked about that. Basically, we are talking about how to move from paper, which is basically having unstructured data, to structured information. Structured information that can actually be used in triggering specific actions. And it's very much linked to the buzzword that we are all hearing a lot lately, digital transformation. I will talk a bit about that, and at the end of my presentation you will see something practical that we are putting together in terms of technology in order to bring this automation and actionable information to your fingertips. First, hope it's working. Yeah, good. I don't know if you know this riddle. The ones that have kids probably do. Anybody knows the answer? It's from The Hobbit. No. Time, correct. Yes. It's about time, yeah. So everything that is around us, technology and changes, are actually on one hand saving us time, but on the other hand, in a lot of instances, are eating our time. The industry itself, whether we talk about technology or the legal industry, is flooded with information. We are struggling to find time. We are struggling to find the balance between the work and private time, to spend also quality moments with our beloved ones. So from the philosophical perspective, the digital transformation as such is targeting, to a certain extent, saving time for us. And I'm happy that during the presentation that I've seen in the morning, quite some of the things that I have also in my presentation are common, maybe in a different form. As you can see here, some data on a global level, the digital transformation and the fact that the world is going towards this digitization is a fact. We cannot escape from it. Maybe if we go somewhere in the mountains and we take a cottage and we don't want to hear anybody else, we take away the social media and any other means of communication, but probably the people that are attending this event are not in that category. So we see a lot of acceleration of digitization, and it's getting back. Forward, forward. Great. Now it's working. Paperless office. We were talking in the beginning about paper. Before the pandemic, we were hearing a lot about paperless offices, but nobody was really paying attention to that, and it was not. Once the COVID started and we were forced to leave our offices, to stay at home, to collaborate with people that we didn't see from various locations, the fact that paper was not anymore the primary means of communication was more and more valid, and the priorities of the companies changed. So now any business has to take into consideration how to move paper from the unstructured data, from the physical perspective to the digital one. And this is basically the need for improving the productivity, so to work better, faster, and also to foster this collaboration amongst members of the team that are basically not present in the same location. So the hybrid working environment is here to stay, although in the last period we see a trend of some organizations actually motivating people to come back to the office, but still, especially when we talk about companies which are having subsidiaries and offices not in the same place, the need of having collaboration tools is extremely valid. Yeah, it's still visible. Last but not least, we are talking about two important aspects. Everybody was talking about that. Information security is absolutely needed to have a system that is providing strong security to the data, to the infrastructure, to the devices that we are using. From a lot of reasons, let's say, talking about data privacy and so relationship amongst companies that are doing business together. And also all the tools that we are talking about that we've seen today are also directed into improving customer satisfaction, so the way that our customers are seeing us. In terms of getting closer to the legal aspects, I think what you see on the screen is pretty similar to what you've seen also in other presentations today. This is from our perspective, talking to our partners, to our customers from the legal environment. So case management is quite important and specific to your industry. Contract management, also invoices and managing the information and the exchange of financial data with our partners, with our customers. Last but not the least, secure archiving of the documents, and also managing the incoming correspondence. I've heard from Mr. Mihaila that 34%, if I'm not mistaken, of the documents that you're receiving were digital. Probably this trend will continue and it will be more and more, but still paper will be there. In your case, 34% is digital, but there is still paper. So we'll need to handle this in the future. And from this perspective, the challenges for you are related to how this, let's say, information that's contained either in the electronic or in the paper documents are, on one hand, kept in a secure environment. From GDPR perspective, from know your customer perspective, and also regulations, this is one of the significant challenges. Also talking about the last point here, the volume of that data which is exploding and is a real challenge to handle all this volume of information that is coming to you. The remote working I was mentioning before, people have to work together on the similar document and in a secure way. And in the same time, when you talk about the office part, there is a lot of manual tasks that are still performed, which are not bringing too much value to the organization, and basically they are bringing costs. But these are the, as we see them, these are the challenges that are quite present in the legal environment, and us as technology providers are trying to bring technology closer to you to solve these problems that you see. Why Canon? Very few words about us. Probably you are accustomed to see Canon cameras from 80-something years ago. We're starting to use imaging and to work with documents and with the information. Lately, we are investing a lot in diversifying our portfolio. We are one of the most innovative, if not the most innovative companies in the world. For the last 35 years, we are the only company in the world that is constantly in the first 5 places as number of patents registered in the US Patent Office, which is actually showing that we are in the forefront of technology when we talk about information and about documents in general. One of the points here you can see down below in the right-hand side. In the group we have also other companies that are complementing our traditional line of business, which is on one hand cameras, but most importantly for what we are talking about right now, we are talking about multifunctional devices and scanners combined with technology that is actually extracting data from the documents, even if we talk about OCR technology or document management systems. And the solutions that we can actually provide to you are somehow listed here, but they are not the only ones. Talking about secure document management systems, digital mailroom solutions, invoice processing, contract management, which are only a few of those that can be developed using our technology inside your organization. This would bring, obviously, using these technologies would bring a lot of benefits to you for the future, in terms of being more productive, saving costs which are not managed maybe properly at this time, saving errors or eliminating a big part of the errors that are done by the people that are working with data and with information. Last but not the least, improving the collaboration amongst people in a secure way, and being faster and more productive will actually improve the way that you are seen by the customers in an increasingly competitive environment. As one of the speakers was mentioning in the morning, the ones which are the most adaptive will thrive in the future, and actually adapting ourselves to the requirements and to the challenges that are visible in the industry at this moment is critical for any organization. Now, getting closer to let's say a more concrete topic, what actually that could mean for you. We have here an example of how technologies can be put together for an integrated solution that is treating a challenge, a problem, a pain. We've seen throughout today that there are a lot of systems, there are a lot of technologies available that are doing sometimes pretty similar tasks with tweaks on one hand or the other. The critical topic is how to integrate the solutions, because none of them is doing actually everything. So we have to put together the technology in order to work seamlessly from the beginning to the end, in order to provide an actionable information in a structured way. So here what you can see on the table is a kind of a end-to-end process, where in the beginning we are talking about input in the organization of either an electronic document, which is coming by email, for example, or you have to digitize, as a first step, a paper document. Digitizing a paper document can be done either by using a office multifunctional machine, or if you are at home, you can have a small scanner that is actually doing the same stuff. Or if you have large volume of data, as Mr. Mihaela was also mentioning, you can use a high volume scanner. This is bringing the electronic document in the organization. Then in the second part, actually you have to extract the important data from that document in order to use them afterwards. We call them metadata. We can define on each type of document what kind of data it has to be extracted from there, in the same time to keep the image of the document for example, in a PDF form. Then for this, for example, in our case, we are using a proprietary technology. It's called Scan2X, which is doing this action. It's taking the electronic document, extracting the data, and organizing this in a, let's say, structured way. In the same time, keeping the image of the document in a PDF format. Now, this has to go further in the process in order to be used in a workflow. In some cases, they are proprietary, either ERPs or even CRM systems that are not providing necessarily an API, so you cannot connect directly between the applications. So in this case that we are having here, we are working with Thailand, a Romanian-based company that is actually providing robotic process automation proprietary technology to fill the data that we were scanning and we were extracting from the documents in Wolters Kluwer's LexForce, which is then organizing the data according to, do I have time still? Thank you. According to the needs in a specific case, which is legal environment today. We also, as again a proprietary provider of technology, we are also having our proprietary technology, which is called Therefore. It's a more generic application. It's a clean sheet of DMS that you can adapt to your needs. But in our case now, we are talking about LexForce, which is adapted to the needs in the legal environment. Next, we will see a small movie which is showing what is actually happening. It will be quite fast, so I'm trying to pinpoint a little bit what is happening there, because you'll not be able to see very well what is going on. And this is actually what is happening when you use fast technology that is replacing to a certain extent the manual work of the people with very high accuracy. If you can go to the next slide. So basically what is happening is we are talking about So these were, let's say, the examples from the technological perspective, how to put together the hardware part, which is, in our case, multifunctional devices and the scanners, together with the extracting and information management software that is also provided by us, together with the robot automation and also the CRM that is actually handling the proprietary information and the specifics of legal departments. I think that was it from my perspective. Thank you very much. I respected the time. I think I'm okay. Right?
Absolutely. Thank you very much. I think we all love to see technology in action, so we saw that here. Very much appreciated. With that, I propose that we go straight to our next speaker, Mr. Constantin Boudun, who will tell us everything about e-signatures.
Thank you very much for your invitation. Yes, I will present some aspects, benefits and risks for digital electronic signatures based on their categories and types. Nu am apăsat. Da? Ce anume? Păi atunci prezentează și eu îi dau cu am pe laptop. Dacă auziți? Pot să bag eu dacă... switch and
They'll find. Of course. Okay. Yeah. Thank you. So then we switch the presentations and we go straight to you, Douglas.
Thank you. I don't know if I have to press any buttons here, so will you press next on the slide? I thought I had the privilege of being the last speaker before the lunch break, but I'll leave that one to you. So I'll keep it as short as possible in order for you to enjoy the lunch prepared by the organizers of this event. I'm Dragoș. I come from CITR. Romania is one of Romania's largest insolvency practices. And what's specific to our work is the high volume of data and high volume of legal work that we do in these procedures. Oh, my presentation is up. I've been told that, basically the three main points of my presentation, but we'll go through them later on. I've been told that putting numbers on your slides makes you more credible, so I started putting some statistics on the screen. What we can learn from this is that COVID was not such a bad thing, because as we all know, since COVID started, both private practices and state institutions have invested a lot of effort and money in digitalizing their operations. However, looking into some studies by McKinsey, and the Harvard Business Review, we found out that only 35 of organizations' digital transformation efforts really ever succeed. And that's what I'm going to talk about today. I'm going to go through some of the lessons that we've learned while implementing our digital transformation strategy. I'll go faster through this slide because most of the speakers before me have already covered all of this information. So basically, be it that you come from a big law firm or a smaller practice, you still have great volumes of work, you still have some rules that you have to comply with, and you want to focus yourself on the impactful work that you and your colleagues can manage. Also, we are all lawyers or legal professionals, so we act in an environment that's governed by laws or by rules. However, what we found out, and you'll see with an actual example later on, we found out that however clear the rules are in our laws, our organizational rules in our offices aren't as clear or aren't as complied with. We actually found out that in each of our offices within Romania, we have a national presence. In each of our offices, people interacted differently with our colleagues when it came to, let's say, applying a registration number on a document, or justifying some business expenses, or drafting a table of debt when that concerns the debt against an insolvent company. So all of this, while auditing our operations, all of these took us to the point that we had to optimize our processes before trying to digitalize them. Also, one of our needs, and you'll see later on that it can be done, was to actually show complete dashboards to our stakeholders. And by stakeholders, we don't necessarily mean our statutory stakeholders. Also, the creditors in our procedures are our stakeholders. So if we were to go and present to, I don't know, a bank, let's say, how much money do you are you standing to recover from certain bankruptcy or insolvency procedures? We can do that by digitalizing our whole workflows. But let's go on to the how of the process. Do I need to press it, or will you? Right. Okay. Okay. Right. I pressed it once. Oh, how? Okay. So it's working. As I told you before, there are 3 stages of adopting a digital. We did it in 3 stages. First stage, identify. Second stage, develop, and third stage, deploy. Identification was, I already talked about it. It implies an audit of all your operations and conceptualize those operations into simple rules, of course. Lawyers don't think only in rules, because we all think in exceptions most of the time, or at least most of my colleagues. I don't know if that's because of the way our laws are drafted. However, you need to find the common denominator to the whole process, and I'm not talking about the legal rule, but the operational rule that you want to digitalize, in order for your legal obligations to be complied with. Going to the development stage, we adopted a strategy in which we formed a core team of professionals from each of our teams, internal teams, in order for us to have an input from each and every aspect of our activity. Because we do a lot of legal work, but we also have accounting work. We also have effective office management work, and also we have asset management work in our insolvency procedures. And then we had one question that was also asked before: do we want an already available general software, or do we want a tailored solution? We researched a lot of software providers in order for us to find out whether or not their solution was applicable to our field of work. However, and I'm really glad to say that we contacted a software provider that gave us a tailor-made solution. The deployment phase was one of the most challenging parts, because however much we tested our software and our digital transformation solutions, real life kicked in when we went live with the software. So we had a lot of mistakes. We had a lot of blockages that we basically had to figure out a way to solve. Even this week, we had a problem with our databases that shut off over the weekend. Some of my colleagues were out on leave or out signing documents at another location, and we found out that a lot of documents that we generated had some pretty big mistakes in them. And luckily, we were still in the time limit. We redid it, but it shows a lot of importance on the way in which we treat our processes and how attentive we have to be in order for us to achieve true digital transformation. The second slide from the how part of my presentation is actually borrowed from the IT world, and I thought it would be interesting for everybody to apply this. I don't know if this works again, but fine. I was about to talk about agile development. I learned this term from my IT colleagues, which and agile philosophy basically means that you have a request for something to be made. You develop that request, you put it in practice, and then you collect the feedback. And basically, that's the first feedback loop. And then you have more and more feedback loops until you have a well-polished product. I don't know how can I go to the next slides. So 2 slides over, if you can help me with that. Okay, yeah. No. Fine. Yeah, so I think you have to open up your phones. I just realized there's nothing in my rear. So I'll just get to the point with the challenges. Basically, the biggest challenge that we faced was company-wide adoption. First of all, this adoption meant that my colleagues had to do things in a different way. Well, that's a really nice thought. However, when you have fires left and right and you have urgent matters you need to attend, I can understand that is really tough. That's a really tough job to do, especially if you're not technologically you don't have formal tech education. Second of all, the involvement of the team. You need to keep your team involved and informed, because when your provider will come and give you the product, it might have several versions, and you might have your colleagues or employees trained on version 1, and version 3 will be totally different, and they will not know how to apply it to a real case. But regarding adoption, I think that the most important thing is that each and every one of your stakeholders, be it your employees, your shareholders, or your clients, must know what the main points of advantage are. So, or what's the ultimate objective. You don't want to digitalize your operations just because it's a trend, or just because it's a buzzword, or just because you want to market yourself. No, you want to digitalize your operations because you want to be more efficient. You want to have the most impactful meaning in your projects, and you want to concentrate yourself on the most intellectually stimulating work, not on drafting notices, not on putting data into an Excel or trying to figure out what a ton of information can be all about. I think the agile development tag there was left by mistake, but another of our challenges was how to get over the first fails, because we went live with certain modules without having them tested in a real life scenario, because we couldn't have known what the outcome was. If it was 90% perfect, that was fine with us, because you can fine-tune it all the way. 90% perfect is better than 100% perfect in 5 years. And that was our philosophy, and what I can advise you to do is to be prepared to face the failures. Be prepared that your, I don't know, your document generating software won't work like a charm the first time. Maybe the front office registrating software won't work perfectly all the times in the first 2 weeks. However, the lessons that you learn from implementing that type of software in your organization will make you realize the benefits. It will make you optimize your workflows. And the final advice: enjoy the little wins. Enjoy when the little wins, when you have, I don't know, the 50,000 notices sent in one day. We did that this year. Last year I was talking about the first major insurance bankruptcy in Romania. This year we were named as the liquidators of the second major insurance bankruptcy in Romania in the last 2 years. So these are little wins that we can actually measure by the fact that you have digital transformation software, and you have digital tools in order for you to cope with the volume that your work implies. I know I might have some time left, but I will also love to hear Mr. Bourdoun talking. So yeah, my last slide was simply an advice to stay flexible and adapt yourself to what happens in this world, because yeah, I agree, AI will kill the lawyers that do not adapt with them, and I would like to add that technology will eliminate people that will not adapt to it from the professional world, of course. So yeah, thank you very much, and I'll give the mic to you.
Absolutely. Thank you very much. Indeed, so I think that we can get some questions, and then we the that's even better, because I'm sure that there will be questions. First of all, from the audience. Can somebody give a microphone there? Oh, you'll get a microphone. Yes, thank you.
Yes. Working, yeah. So I would say that first of all, you have to look into the data and to structure it. What kind of repetitive actions are done in order to identify if it can be put in a technology which is taking care of that without you to verify it or to actually do it yourself. Not everything will be probably possible, because as also Mr. Ghițu was saying, there are a lot of exceptions that cannot be treated necessarily in a system that will be probably still done by the people. It's definitely case by case. I mean, for sure it will be a mix. I mean, if the documents that you are using are not 100% structured in the same way all the time, then for sure you have to adapt each time when you have a different document, and some of the data will still be needed to be input manually. But if you are able to automate maybe 80% of the information that needs to be extracted, that in terms of time, it's a lot of gain. Yeah, it's definitely a possibility to improve all the time. We actually do the same with our platforms, with our software, and for sure LexForce is doing the same. Any kind of software provider is improving constantly based on the feedback that is coming from the actual users. Without that, it's very difficult to imagine what can happen in the real life if you are not in the industry. So, yeah, it's probably the case also for LexForce that is continuously adapting its versions.
Mm-hmm. That's always a question.
This is
absolutely.
all the time a progress loop. Correct. It's a lot of information that is actually coming, and it's not necessarily the same as in the past. So all the time you'll have new cases that have to be treated. But this is the beauty of it. So we'll not have every time the same stuff. We'll have to learn as AI actually is learning by having multiple data, multiple cases, and adapting out of multiple cases, and actually reducing the errors that are happening.
Thank you. I'm looking at you, Adrian. Do we can we go to Mr. Boudon for the, okay, if you please take the floor for e-signature, please.
Thank you, thank you. Okay, so I will start from some definitions. I will present three concepts that are definitions from Regulation ADAS 910 from 2014. So electronic signature means data in electronic form which is attached to or logically associated with other data in electronic format which is used by the signatory to sign. Another definition is advanced electronic signature, means an electronic signature, you see I put different colors, that meets the requirements set out in Article 26, and here are the four conditions. It is uniquely linked to the signatory, it is capable of identifying the signatory, it is created using electronic signature creation data that signatory can, with a high level of confidence, use under his sole control, and it is linked to the data signed in such a way that subsequent change in the data is detectable. The third definition is for qualified electronic signature, means an advanced electronic signature that is created by a qualified electronic signature creation device and which is based on a qualified certificate for electronic signatures. So, from definitions, if we try to have a visual of these definitions, actually these definitions reflect some categories, not some categories and types of electronic signature. We have a large type of electronic signatures that can be implemented with many procedures and techniques, as I will show you further. There is an included category of advanced electronic signatures that is part of this big category of electronic signatures, but fulfills that four conditions. And finally, we have a specific type of advanced electronic signature that is qualified electronic signatures, and conforming to the EU regulation is equivalent as a legal value to handwritten signatures. If we want to have distinct categories, we have this in the right part, simple electronic signatures. So is that part that of that electronic signatures that are not advanced, right? then the non-qualified advanced electronic signatures, so the advanced electronic signatures that are not qualified, and the type qualified electronic signature. This would be actually the three, the two categories, and you will see that actually qualified electronic signature is not a category but a type. Many people from reading the definitions and from experience that we have, many people have in mind these categories. So electronic signature, advanced electronic signature, and qualified. But it's not like this. It's like here. It's something that each category includes the other. And this is very important also. So electronic signature is an abstract concept. It does not refer to any specific technology. It can be achieved through different technologies, as shown in two examples below. Simply specifying the name of the signatory at the end of an electronic document, in a Word document, falls in the definition. So we have an electronic signature. Attaching a photo of the handwritten signature, or even the photo of the signatory to a document, falls also within the definition, electronic signature. A scan of the document hand signed by the signatory attached to an email falls also with this definition. But okay, the question is how much I can trust these types of electronic signatures. An electronic signature cannot be assessed and understood, so evaluate if we can trust or not, without specifying the technology. I mean technical and procedural mechanisms by which that electronic signature was created. So a type of electronic signature is identified by technology by which it is created, and also by technology we mean technical and procedural mechanisms. So in the category of electronic signatures, we have many types. There is no how to say, a list with them. Can be any technical mechanisms and procedural mechanisms in order to comply with the definition. Going further, what is procedural mechanism for electronic signature creation? The procedural mechanism is a set of working rules, procedures that a human operator and or a computer system must go through and follow in order to create an electronic signature. This is called a signing policy. If it details also the standards for the definition of electronic signing policies. For example, electronic signature based on the photo of handwritten signature in the document. It is somehow used. Technical mechanism is inserting in an electronic document the photo of the signatory's handwritten signature through a software program. Procedural mechanism is a set of rules on how to use the respective software program, how to associate the signature photo with the signing person, what security measures, if any, are taken to prevent from using the photo of another person's signature. I will pass the example 2 in order to go further quickly. An example of type of electronic signature is the electronic signature based on digital signature. Digital signature is a technical mechanism. So many people said electronic signature and digital signature interchangeable, is the same. It's not the same. Electronic signature is something I already explained. Digital signature is a technical mechanism, one possible technical mechanism for electronic signature creation. It's based on public key infrastructure technology, and the digital signature is attached to a document correlating the digital signature with a document is actually as a result of document encryption, specifically with the so-called private key that only the signer is supposed to have. This encryption can be decrypted with a unique public key associated with that private key. In this way, the signature can be checked, verified. So the technical mechanism is applying a digital signature to the electronic document through a software program in a format defined by a standard. And procedural mechanism is a set of rules on how to use the software program, how to make the association between the public key corresponding to the private key with the person that signed, secure manner, and security measures, if there are any, that are taken to prevent someone else from using a signer's private key. The risk, an important risk that I think it's rising from what I present already. The use of a non-advanced, simple type of electronic signature cannot reflect the signatory act of will. Why is this? Because if it's not an advanced electronic signature, either does not refer exclusively to the signatory, conforming to the definitions, or does not allow identification of signatory, or is not creating using electronic signature creation data that the signatory can use exclusively under his control, or is not linked to the data used for signing so that any subsequent changes can be detected. If one of these conditions is not fulfilled, from our opinion is that you cannot rely on such signature in order to be sure that that document is act of will of a signatory. So here we have this risk. Going further to the category of advanced electronic signatures, in the same we are in the same idea of a concept. So advanced electronic signature is not a technology, something, a type. It's a category that can include many types of advanced electronic signature. I mean, many technical mechanisms and the procedural mechanisms by which can be used in order to generate advanced electronic signature. And the big problem is that a type of advanced electronic signature cannot be assessed as advanced unless the technology, I mean technical and procedural mechanisms by which that electronic signature was created fulfills the 4 conditions, the 4 requirements from the definition. I will pass through this. It's too technical. It's just an example. Sorry. So the risk here in using an advanced electronic signature without having concrete technology that is used is the idea that meeting the conditions of the advanced signature definition is not easy. So in many situations, in fact, very few types of electronic signatures are really advanced. I mean, are really fulfill the conditions. There is no, at this moment, there is no European or national list of advanced signature types, except for one type that I will present later, and you probably know what I mean. There is only a European list of technical mechanisms specifying electronic signature formats for advanced signature, but the procedural part is not specifically regulated by the regulation, by the EDAS regulation, except for qualified signature. So the multitude of possible types of advanced electronic signatures for creating electronic signature means that in the absence of the clear regulation or standards, we cannot establish that an electronic signature is advanced simply by accessing an electronic document. And this has happened. For example, here we have documents that have these electronic signatures. You know, this is a labor contract. And you can see that is not real, cannot be real. It's a company that employ Brandon Stark from King's Landing to do some work. So and but it's possible to be created from us. But is not and many people think that signatures there are advanced electronic signature. This is not true. There are not advanced electronic signature, from the reason that the 4 conditions that I show you previously are, or part of them are not fulfilled. Another example. So here we are using this image of signatures as a technical technical mechanism. Another technical mechanism is digital signature, and if the digital signature is only used as a mechanism, but some procedural steps are not fulfilled correctly. As you see, the software, which is Adobe, for example, cannot say to you that this is a trusted signature. So this is because a software should know, should have some defined list of advanced electronic signature to which to use it. But because there is no predefined list of advanced electronic signature types to be able to see that the signature is advanced, the software will offer to you this information. At least one signature has problems. A software from this without any configurations. Of course, you can learn him specifically for a type of advanced electronic signature that is trustful for you. But this would not be a solution, because if you receive another document signed with another technology or with another technical mechanism, you will get the same warning, and you will not be able to decide if you can trust or no this document. The last definition is of qualified signature. Qualified signature is actually a type of advanced electronic signature. The qualified signature, because in an advanced electronic signature, to which is specifically detailed in the regulation, both technical mechanism and also the procedural mechanism, how can be created. So the qualified signature is the only type of advanced electronic signature for which regulation, ADAS regulation, fully specifies the technology used to create it. And actually, these technologies are created to guarantee the fulfillment of the 4 conditions for advanced electronic signatures. So in the category of advanced electronic signatures, we have this qualified electronic signature, in which technical mechanism is qualified certificate and qualified signature creation device, and procedural mechanisms is the certification policy of the qualified trust service provider and some standards that he should follow. So when we are using a qualified electronic signature, because of the ecosystem that ADAS regulation created at the European level, the software knows and trusts this type of qualified electronic signature, and you can see this also on this screen. The security agency, European Security Agency, ENISA, issued in a report these sentences. So basic signatures like non-qualified advanced electronic signatures benefit from non-discrimination rules. They can be in court, should be, and it must be accepted in court as a proofs. But their dependability is still lower than that of qualified electronic signature, because the signatory may be required to prove the security of the technology being used if the validity of the signature is disputed before a court. So this requires significant costs and efforts that could be avoided and with relative ease for the more established and standardized advanced qualified solutions. It may also be the case that the relying parties means that parts that are relying on the documents signed and so on, have no applications or tool to validate such signature. Such signature means non-qualified signature when not based on standards. In such a scenario, the signature may be legally valid and technology robust, but of limited use. So it's very important to see that these ideas and this advice, it's from European Agency for Cybersecurity. So in conclusions, we have two categories of electronic signature: non-advanced electronic signature, simple electronic signature, and another category, advanced electronic signature. So in category of advanced electronic signature, we have various types of advanced electronic signature: non-qualified and the qualified electronic signature. As a risk, we have risks regarding that the document signed is actually reflects the will of the signatory. So the non-advanced electronic signature on a document does not reflect the act of will of the signatory, should be needed in court for sure and other elements in order to prove this, but only that documents will not be enough. And if you are using a non-qualified advanced electronic signature, it is not possible to know in advance whether a type of signature is really advanced, because there are no national European definitions of advanced signature types other than qualified in the detailed way, similar to the way qualified signature is defined in the regulation. And from this point of view, qualified electronic signature has no risk regarding this. So, the benefits are that all these electronic signature must be accepted in a court, but with limitation from the first two categories and with no limitation for qualified electronic signatures. So there are many things and detailed things that could be discussed about this concept of electronic signatures. We will have, together with Walter Kluwer, soon a webinar on this with workshops which we explain all this concept, and hope you will participate. Thank you very much for your patience, and thank you.
Thank you very much, Mr. Bourdoun. I think that we've all learned a lot again of the world of signatures. There's no such thing as just one type of signature, apparently. That was good to hear that, and we all have to keep that in mind when we sign documents or see documents being signed. I'm looking at the time. I think that we're running behind quite a lot, or at least somewhat. Huh? Okay, so then it's an easy decision. I propose that we leave that is for now. Questions can always be answered during lunch, and I think that we reconvene here in 40 minutes? 40 minutes. Okay, let's aim for 30 then. Okay, see you all in a bit.
Dominic, du-te, Dominic, hai băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai mă, Dominic, bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cea mai bun din tine, hai. Hai, bine, bă, Patrick.
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Bun, dacă ne-am înțeles, atunci hai să semnăm. Bine, ok, te pup, pa, 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 pa.
Cu CertSign câștigi flexibilitate și siguranță.
Dacă am fi fost o cofetărie, de ziua noastră ți-am fi oferit tort și multe prăjituri. Dar pentru că suntem Brico, sărbătorim 20 de ani cu o tonă de oferte. Hai să le prinzi pe toate în magazine și pe bricodepo.ro.
Brico, brico, brico.
CertSign câștigi mobilitate și dinamism.
Și tu vrei să obții 100% online semnătura electronică calificată pentru SPV? Dacă de acum trebuie să depui exclusiv electronic documentele la ANAF, atunci de ce să nu obții și semnătura electronică necesară tot online? Achiziționezi 100% online certificatul calificat de semnătură electronică CertSign prin identificare video la distanță, echivalentă cu prezența fizică. Alege semnătura electronică calificată CertSign care ți se potrivește, pe token sau în cloud, cu valabilitate de 1, 2 sau 3 ani. Află mai multe pe certsign.ro.
Dominic, du-te, Dominic, hai băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai mă, Dominic. Bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cel mai bun din tine, hai. Hai, bine, bă, Patrick.
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Bun, dacă ne-am înțeles, atunci hai să semnăm. Bine, ok, te pup, pa, 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 pa.
Cu CertSign câștigi flexibilitate și siguranță.
Dacă am fi fost o cofetărie, de ziua noastră ți-am fi oferit tort și multe prăjituri. Dar pentru că suntem Brico, sărbătorim 20 de ani cu o tonă de oferte. Hai să le prinzi pe toate în magazine și pe bricodepo.ro.
Brico, brico, brico.
CertSign câștigi mobilitate și dinamism.
Și tu vrei să obții 100% online semnătura electronică calificată pentru SPV? Dacă de acum trebuie să depui exclusiv electronic documentele la ANAF, atunci de ce să nu obții și semnătura electronică necesară tot online? Achiziționezi 100% online certificatul calificat de semnătură electronică CertSign prin identificare video la distanță, echivalentă cu prezența fizică. Alege semnătura electronică calificată CertSign care ți se potrivește, pe token sau în cloud, cu valabilitate de 1, 2 sau 3 ani. Află mai multe pe certsign.ro.
Dominic, du-te, Dominic, hai băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai mă, Dominic, bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cel mai bun din tine, hai. Hai, bine, bă, Patrick.
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Bun, dacă ne-am înțeles, atunci hai să semnăm. Bine, ok, te pup, pa, 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 pa.
Cu CertSign câștigi flexibilitate și siguranță.
Dacă am fi fost o cofetărie, de ziua noastră ți-am fi oferit tort și multe prăjituri. Dar pentru că suntem Brico, sărbătorim 20 de ani cu o tonă de oferte. Hai să le prinzi pe toate în magazine și pe bricodepo.ro.
Brico, brico, brico.
CertSign câștigi mobilitate și dinamism.
Și tu vrei să obții 100% online semnătura electronică calificată pentru SPV? Dacă de acum trebuie să depui exclusiv electronic documentele la ANAF, atunci de ce să nu obții și semnătura electronică necesară tot online? Achiziționezi 100% online certificatul calificat de semnătură electronică CertSign prin identificare video la distanță, echivalentă cu prezența fizică. Alege semnătura electronică calificată CertSign care ți se potrivește, pe token sau în cloud, cu valabilitate de 1, 2 sau 3 ani. Află mai multe pe certsign.ro.
Dominic, du-te, Dominic, hai băiatul lui tata. Du-te, Dominic, du-te, bravo, 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 te-ai detașat, te-ai detașat. Hai mă, Dominic, bine, Dominic. Du-te, 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 du-te. N-ai cu cine, băi, frate, n-ai cu cine. Hai, hai, du-te mai 10 mm, 10 mm mai, aleargă, dă cel mai bun din tine, hai. Hai, bine, bă, Patrick!
Când alții pierd timp, noi îl câștigăm. Ține de tine cum îl folosești. Cu CertSign câștigi mobilitate și dinamism.
Welcome back to the third panel of the fourth edition of Legal Innovation Day. For this panel, where AI is king, of course, what can a legal tech conference can be these days without talking about AI? We asked for this for an expert, and we asked Ms. Larissa Penner, who is head of platform management at Wolters Kluwer, Germany, and she's an expert in digital transformation, digital strategy, and innovation and customer experience. This is driven by previous large-scale digital transformations and programs done by Accenture and Deloitte. She and her team are responsible for the further development of digital legal ecosystems of Wolters Kluwer in Germany. Larissa, I know the impact of generative AI on legal professionals. It's an important one, and I leave the floor to you to show us more. Thank you.
Thank you, Adrian. Ladies and gentlemen, welcome to the last session of today's Innovation Day. And it's a pleasure for me to be here. I know you are a little bit tired maybe and exhausted by the amount of the insightful information that you already got from my previous colleagues. But anyway, the colleagues that are going to present and to participate in the panel with me, Adrian, Jakub, and Ciprian, will do our best to entertain you. So also in the last panel. So basically, let's try if the technique will work. So yes, no, we need to go one slide back. So AI, right? We already had today interesting insights into some AI topic, also in terms of what is Wolters Kluwer globally doing on that topic. And as you can see, I have here my Wolters Kluwer mascot and assistant Robbie with me, who is also entering some prompts into the ChatGPT and providing some answers. So welcome. And so what are we? I mean, we are living in a fast-changing world with a lot of complexity. So what does it mean for us? What do we have to consider also from, let's say, legal professional perspective, but also from our personal perspective? So maybe there is a small example that I brought with me. So basically, as you can see here, when I was thinking, okay, I'm going to Bucharest, it will be nice. And you see in the background, the AI is already producing a picture, so it looks like I'm on a holiday in Bucharest, so it looks like, you know, it's not like a fake, but a real one. And I mean, in terms of changing business models, like, you know, we had business to business, business to computer, and if we listen to our future forecasts, so the business to avatar commercial model is also not far away in the future. Right, so how can we deal with that, and what do we need to prepare in order to interact and be able to act in this fast-changing world impacted by AI? So maybe let's have a look on what influences AI has on the professional life of legal professionals, and as you can see, it has a significant impact. So basically, all legal professionals, including lawyers, paralegals, and legal researchers, are impacted by that. And I summarized the key influences in the legal field, so the 10 most important ones from my point of view, which is document review and due diligence, legal research, predictive analytics, of course, contract analysis, e-discovery, legal chatbots. By the way, the very first one I discovered with Dentons when I visited them in 2018. So they were telling me, Larissa, we are currently developing our chatbot with our lawyers by ourselves. I was really impressed at that time because they were so keen on in the legal tech. I haven't expected that. But as you can see, it's like an evolving process. Of course, automation and routine tasks, cost reduction, enhanced decision support, and ethical and regulatory considerations. So, but I mean, what do we need for that, right? And in order to master everything, so you see the European Union is developing the artificial intelligence legislation, which the majority of you for sure maybe heard or know about, right? So here I will not bother you with all, let's say, legal terms or whatever, so I just want to say I will provide a briefing on the core topics. So it's a draft of Artificial Intelligence Act from 2021, which is about regulating the design, development, deployment, and life cycle of AI systems, and the draft of Artificial Liability Directive from 2022, which should make it easier for the victims to claim damages suffered from AI systems. So let's have a look. So the AI scope is it's a risk-based approach to regulation, and it's about it's a balancing act to create a profitable market and protection of European fundamental rights. So, and to understand what's basically the timeline, as you can see, it started already in 2021, not that a long time ago. And so the AI Act was drafted by the European Commission, and it was last year adopted by the EU Council. And currently, we are basically in the EU Parliament adopts the position on the AI Act in plenary. And the next step will be to finalize the version to be agreed as part of that, and to create and publish a liability directive, right? So, and then next year they plan to indicate date for entering into force, right? And basically in 2025-26 it will be rolled out. So then it will be applicable. So as you can see, it's a challenging timeline for our colleagues, but anyway, even though there is this timeline and a kind of roadmap, the reality is unfortunately far behind the technology. And we will have a look to that closer in the presentation in the next steps. So maybe a short insight into what is defining an AI system, right? What is going to be regulated? It's the machine-based system, then varying levels of autonomy, explicit or implicit objectives, so that generate outputs such as predictions, recommendations, or decisions that influence physical or virtual environments. So that's in the scope of the definition. Then, what is the scope of the AI Act itself? So it applies to all participants, natural or legal persons, in the AI value chain, and it includes providers, deployers, importers, distributors, provides rights to affected person in the union, and it's important, it's an extraterritorial effect. So as I already said, it's a risk-based approach to regulation, and here you can see the pyramid. So basically, it starts with the unacceptable risks, which are at the top, right? And the regulated high-risk AI systems and new foundation models and generative AI, the topic that we will have a look closer on later on. So authorized subject to requirements and obligation to gain access EU market, and limited risk by transparency requirements and data retention. Yeah, and then the question is what happens if you don't comply to the rules, right, and regulations? And that means that there is, it's in the responsibility of national supervisory authority. So member states can elect which local regulatory body assumes authority. Then wide powers to compel access, inspection, evaluation, corrective actions and preventions. And of course, the fines are really not to underestimate, right? So you see breach of Article 5 prohibition up to 7%. Non-compliance are up to 4%. And non-compliance of AI system or foundation model with any other requirement up to 2%, and supplying incorrect, incomplete, or misleading information to authorities up to 1%. And I mean, it can be huge amount depending on the topics that you are driving, right? If you are, for example, a large enterprise in different industries, it can be extremely costly. So, but what's actually here the overlap with the GDPR? And I think it's important to remember that the compliance with the GDPR is a precondition to permitting the placing of AI systems on the market. So basically, that's the main thought here. And maybe before we will dive to the next topic, I wanted also to provide a small overview about the unacceptable level of risk in prohibited AI systems. So of course, the further we are diving into the artificial intelligence technologies, right, the threats that all of us are perceiving and realizing, such as manipulation of human behavior, right, through subliminal techniques, is of course prohibited. Exploiting vulnerabilities related to personality, traits, age, or ethnics or physical mental ability. Real-time remote biometric ID, so profiling the risk of reoffending or untargeted internet scraping facial images. And basically this is what I was talking before in the very beginning of the presentation. And of course, social scoring of individuals leading to detrimental or unfavorable treatment, unrelated, unjustified, or disproportionate. So, but I mean, to make it, let's say, more tangible, what is a company as like Wolters Kluwer, who operates with a lot of data and content regarding the AI topics, right? As you can see, generative AI on this picture has a lot of sub-levels, right? And we are talking here about the deep learning. So generative AI is a subset of AI that focuses on creating rather than recognition. And as you can see here, the level on the unsupervised topics is really high. So on the algorithm bias, and that means basically, so the challenges that we are facing here, I think some of you already also encountered, and we will ask the colleagues who will join my panel, what does it mean really if you are dealing with that, and how it is impacting the operations within the law firms and companies. I don't know. So, as you can see, the current shift has moved into generative creative-centric models, right? And the artificial intelligence technology can produce various types of content, and it brings, of course, a lot of advantages. So the performance, productivity, scalability to other fields, but it brings also some disadvantages with it because it's too costly to train and to maintain it. We will see some figures in a minute. And basically, I mean, the majority of companies just cannot afford, you know, to produce foundation models for applying AI on their content, for example. And trustworthiness and accuracy, it could be biased on data, which is not annotated, and also when it's basically hallucinating. But let's have a look maybe on the figures just to understand, is AI a hype or a trend? And as we can see here, many companies have not delivered because they have promised what they have promised because of this inaccuracy issues. And as you can see, it's really immense. So basically, it lies between 60 or 70%. And if I remember the Wolters Kluwer Germany, we had like the very first workflow solution for construction law, which had already contained this this recognition topics, and we reached to achieve like a variance of 88%. But it was really extremely cost intensive. It costed like a big implementation project in the end to make it happen. So, and if you want to do it in, let's say, large scales, it's almost unaffordable. Adrian, I don't see the here the slides. Is it? Just 1 moment. Oh, okay, so it's back. Yeah, and as you can see here in the chart, right? So the investments are, the high investments lie within this deep learning, so the generative AI part. And as I said, for the majority of our, let's say, people in the law industry, it's unaffordable, unfortunately. Here I have also brought with me a chart, just to have a look how the internal legal teams are using AI. And as you can see, the majority of them are using it for increasing efficiency, of course, right? While working through documents, for example. In researching matters, as Magdalena presented to you today in the second panel, in the first panel. So basically the GPT summarizations, this is also what Germany will launch, for example, this year even, and to provide best arguments for lawyers, for their strategy for the courts. So it's really growing. Yeah, drafting documents, streamlining work, and document analysis. This is also what we are, for example, as a company, heavily focusing right now. So, and I think this is the key slide of the whole presentation. So basically 3 steps to make your organization AI ready. What does it need? Yes, of course, we say content is key, and the domain expertise of Wolters Kluwer in Germany is our primary and secondary content, right? And in order to, let's say, build and enhance and expand our digital legal ecosystem, where we want the legal professional, to work in, it's important to have a proper database. So without it, AI doesn't really make sense, actually. So you have to have a proper data storage database, right, which is a basis. Then you need to set up a proper workflow automation and analytics in order to measure where repeat work is conducting, can help guide where to automate, right? So then basically you structure it, and then based on the top of that, it makes sense to apply artificial intelligence and create some workflow support and enablement so that you can be more concise, more efficient, and basically more successful in what you do. And here we are, as a majority of you may be facing the same challenges, right? So we understand that in order to provide this new, let's say, expert solutions or digital solutions based on our, as I said, primary and secondary content, we need to touch also, we need to rethink and to reinvent how we are working with our authors, right? We are also a publishing company, and basically to create it more to digital, the content, and also to work more intense with the metadata to prepare this data storage, as I said, basis. And so these are the challenges that we are facing. And I think the majority of you will have some similar challenges. And before closing my presentation, I would like you to have just a short look on the time spent and traffic on generated AI. And as you can see, I was really surprised that it was dropping, right? So you can see here, like there is the evolving curve where the ChatGPT was using by the users, and then you can see there is a decline, which was really a surprise. So I think in the end we will see, like when the time goes by, so is it a hype or a trend? And we will elaborate on that topic also with my co-presenters. So let's stay tuned. Thank you very much.
Thank you, but before that I would like to ask you something. So we are now working on some AI. I saw some new regulations which will come that we don't know yet. And then if we do not comply with them, we are risking up to 7% of the revenue of the company or the revenue of the AI. I was not clear on that.
So I'm not sure it was like, can be
In the beginning of the slides,
Yeah,
it was, if I'm not complying with Article 5, if I do remember well, I will get a 7% fine. But from the turnover, so if I'm a big bank and I'm doing a small AI somewhere in the corner of my bank and this is not complying with Article 5, I'm risking my whole business?
7% only.
Yeah, just only for it's okay. It's okay. Now I'm happy. Now I'm happy.
But actually, it's a big risk, as you understand. So that's why it's important to deal with that matters early on. Also, we as a company already started, to tackle that issue and to understand how to prepare ourselves. What I already showed you.
Okay, that's that's very, very important to understand, because from my point of view, the technology is way ahead those regulations, way ahead.
Exactly,
It's
this is
like
what I said.
Yeah, it's way ahead, and you develop something, you spend money, you pay money for these investments, and then you just realize that they are not compliant. And okay, you realize after 3 years of investing, and maybe.
Yeah, but also the costs for compliance and security increased immensely, right? So, I mean, it's not a secret, but I would say, but in our case, it's up to 30%, right? And no one was predicting it within that short period of time, basically to invest their additional money, right? But it's inevitable and it's necessary.
Indeed. Thank you very much. I think it's time to call for your colleagues on the scene. I would like to invite Mr. Jakub Donal. He is a member of the Presidium of the Union of Czech Lawyers. He's member of the Chamber of Commerce of Czech Republic, arbitrator of the Court Arbitration at Hong Kong International Arbitration Center, and an AI enthusiast, as you will see, because he already tested something in the break. So thank you very much, Jakub, for being today with us. Also, I would like to invite Mr. Adrian Spas, and I think, Larissa, he will prove you wrong, because he's the CEO of Vatis Tech, and their AI, I think, is way above those 70–80% of accuracy. But Mr. Spas has started Vatis Tech, which has a mission to provide user-friendly, multilingual, multi-domain speech-to-text technology with accuracy comparable to human performance. And we've used it, and yes, it's working, and we know that it's working, and you'll see some demo if I'm not wrong. I picked a little bit before this. Also, I would like to invite Mr. Ciprian Chioran, Chief Legal Officer at Czech Bank. Over 23 years of experience. He is also the Vice President of the Association of Legal Advisors in the financial and banking systems. Indeed, we need to find out if we are ready for AI and if we are risking 7% of our business if we use AI in not a proper way. Many thanks, Larissa. You have the floor. Many thanks again.
Thank you, Adrian. So, Jakub, Adrian, and Ciprian, I'm excited and welcome to the last panel. So then I would say let's do the presentations, and then afterwards I would like to ask you some questions, right? So, Jakub, the stage is yours, please.
Thank you. Thank you. Do you hear me?
Unmute.
So again, can you hear me, please?
Yes.
Okay, so can you start the presentation, if I ask you? So, ladies and gentlemen, I'm really glad that I can tell you some words about AI implementation process in Eros ETL Global. My name is Jakub Dohnal, and I'm a managing partner of a Czech legal company which is called Eros. We are about 100 people, and since last year we use ChatGPT on our day-to-day basis. You may ask how we combine the tradition and some kind of innovation in this field, and I have to say you that I found this time very breathtaking, and I think that we are in the beginning of breathtaking era with ChatGPT and artificial intelligence. I don't know if you know that ChatGPT can speak now. If you have application of ChatGPT, it can speak to you. You can use it as a Jarvis from Iron Man, if you know that movie. As we are not such a regulated as we are independent law firm, we implemented ChatGPT on our day-to-day basis. And if I want to be practical, I will show you how. Because don't you know who hate the ChatGPT the most in our law firm? The lawyers. Since last year, when I first used the ChatGPT in my law firm, I made some small show for my lawyers, and I tell them, well, gentlemen, do you see, ladies and gentlemen, do you see this tool? It will change our lives, and I strongly believe that this is the future. And my lawyer colleagues said, it was the reaction, but my support team was as keen as me, so I've decided to implement the AI system from above, from the ceiling of our company, and now we have the AI team, which consists of 6 people, and it consists of 3 lawyers, including me, and 3 support team, because our principal general Petra Hučíková was keen on artificial intelligence. You know, do you know what is the main problem to implement artificial intelligence into legal team? How to popularize it for people? Of course, the people. So you have to be smart, you have to use it and show them the possibilities of the ChatGPT. For first thing, when I implemented ChatGPT, I needed to show to my team what it can do. So on some Friday evening, I said or write to my colleagues, well, my colleagues, you know, you all have access to ChatGPT premium license. Do you want to use it? Well, try to script or prompt this. I like the TV show which is called The Suits. Please give me 5 similar TV shows which I can see on the weekend. It's such as easy, but it's something which is really functional. If you want to use ChatGPT, use numbers. You know, give me 5 arguments, how can I seize the valid commercial contracts. Give me 20 cheap HR benefits. ChatGPT in our law firm already saved thousands and thousands of euros because it's something which can help to your brain synapses to be your personal trainer, to be your personal consultant. And if you are thinking about situation in your firm, you can use ChatGPT. For example, I have important client. The client hasn't paid my invoices for, I don't know, 2 weeks. I do want to know 5 arguments how and why he have to pay. Or I have very important people in my company and he doesn't want to fulfill his rules. How can I be concerning on conducting in the situation? And that's the way how you can implement ChatGPT into day-to-day basis. As previous speaker said, there are many inventions and innovations that are going to be here in, I don't know, 1 or 2 years. If you do not follow this way of artificial intelligence now, if you do not train with ChatGPT, you won't be able to fulfill your way to implement ChatGPT or artificial intelligence in your firm. If you want to implement it, I strongly recommend you to find some ambassador in your firm, ambassador of artificial intelligence. Please raise your hand who don't have time to practice with ChatGPT, who don't have time to be keen of artificial intelligence. Is there anybody in this auditorium who don't have time to do that? Yeah? And what do you do if you do not have time in your big firm? Delegate. So choose one person of your law firm and tell them, do you understand what the artificial intelligence is? No? So read about it and make a team. Make a team. Don't waste your time with something about self-study or something if you are not keen about it, but make a team and delegate. Search, search the information, make some chat group in your law firm and exchange the companies, exchange the information, exchange the things that you can do with ChatGPT. We have some discussing group which is called ChatGPT Commando. The name was, of course, invented by ChatGPT, and we exchange our information. So now, in our law firm, we create timelines with ChatGPT with code interpreter. Of course, we can do it in Excel, but do you like Excel? I love Excel, but many lawyers don't love Excel. So these are all the things that ChatGPT can do just now, these days, and you can be part of that breathtaking times. So, talk about unuseless material. Don't use the things that are not suitable for the things that are not good. This is Petra. Petra Hučíková is Eros AI team leader. She is the lady that I designated to be the leader of our AI implementation process. And everybody loves Petra. Petra is the best person in our company. He is really skilled, he is really kind, and we want about 4 or 5 Petras. So we are trying to clone Petra by ChatGPT. It is some kind of sci-fi, but you can do it by yourself in the company because you can do it by ChatGPT custom instructions. Many previous speakers said that ChatGPT is hallucinating. Did you hear about that? That there are some informations that are not true. Well, I don't think so. Can I have one more question on you? Do you know what is the capital city of Czech Republic? Yes, you know. Can you tell me what is the capital city of Czech Republic? Prague, of course. But as we are from the smaller cities, for example Brno and Olomouc, somebody could say the capital city of Czech Republic is Brno and Olomouc. And that's the reason of hallucinating of AI system, because it's generative pre-trained transformer, generative language model, so it takes you or gives you the most predictable answers to your questions. So 98% people says main capital city of Czech Republic is Prague, but we from smaller cities says, well, it's Brno or Olomouc. And it's the problem of generative pre-trained models. It says only the things that you do it to informations. When I wanted to be practical, I can show you my personal settings of custom instructions, because the ChatGPT is not in this room. ChatGPT has no information about you unless you give it to information to the system. So I gave some information about my personal settings of ChatGPT, and there is some sentences that I want to read to you and explain the things. You have several roles in you. I give the preposition to the model. You are inquisitive lawyer, copywriter, HR consultant, and mentor with 20 years of experience, because ChatGPT is everything. He's cook, he's driver, he's HR advisor, he's astronaut. If you want to do it, your tasks, you have to give it instructions. You are multidisciplinary. I want to be addressed informally. My name is Jakub. This is the thing why my ChatGPT is talking to me by my name. And there is nothing new under the sun. Do you have something which is called attorney trainee or paralegals or trainees at all? And do you remember when your best worker in your law firm came for the first time to your firm? Was he as good as he is now? No. You had to give him the instructions, and ChatGPT is the same type. So You are something, you have to do something, you have to act like something. And this is the 50% of success in ChatGPT and AI models. This is the way to exchange the information in your chat group inside the law firm. I'm going to ask you for mostly these types of outcomes: legal articles, LinkedIn posts, and general advice, project implementation, and etc. When I work with ChatGPT, I use it for some role models, I use it for some situation, and these are the most typical situation. Now, do you have experience with ChatGPT when the text was not in a formal type that you wanted to be? I mean, you asked some question and it was very long, or it was very short, or it was not structured. Do you have some kind of experience with ChatGPT? And again, it's the same as the paralegal or junior lawyer and all these things. You know, in Czech Republic, we have really big problem with young lawyers, because attorneys are not as popular as it was before. The job is not as prestigious as it was before, and many of my colleagues says it's a very big problem, and you have two choices: either to cry about it or to solve it. And ChatGPT can exchange paralegals in very short time. So if you want to act him on your way, you have to put some instruction into it. So the article should be about 2,000 words and structured into paragraphs and subheadings. There should be about 5 paragraphs or text under each subheadings, and the title of article should always be made to target the first page on SEO and be eye-catching. Always give me 3 variations of headlines. So you can always set the ChatGPT and AI system in the future by your way, but there will be a biggest chance for you, and this biggest chance for you is called proof by human. You know, even nowadays you have many free templates of contracts. I think that it's same in Romania as Czech Republic. Is it true? Free templates of contracts. You know, you have so many articles on internet which are free, and your clients and entrepreneurs can find many informations that are free. But you are the person who will be proved by human, and this is our future. We can't stop artificial intelligence, but we, with our experience, we will be the persons who can use it. By the way, we have some web which is called elaw.cz, and they had many, I think 4 answers about artificial intelligence. Well, Mr. blah blah, I made this text by artificial intelligence. Can you please prove me that this is true? So just think about artificial intelligence in that way that you will have the stamp and you can exchange your paralegals. At least that one who you don't want to have in your team. But this is the future of legal services. You know, we can do particles in parts. Again, if you have new people or new person in your legal team, you give him instructions. Do you understand what did I say to you? Yes. Can you please repeat my instructions in 4 short sentences? These are the things that you can put into the system, and they will be same all the time. Can I see the time, please? So this is the magic of this is a magic information of ChatGPT. I know you can't read it because there are so small letters, and I know that I can't use small letters, but I wanted to show that magic of ChatGPT. These are some information about my colleague Ondra Stehlik, which is sitting here. He is really skillful M&A lawyer, and he really hates to do any marketing materials. even though he is really a skilled lawyer. We need to market him, but he don't want to be accompanied with it. So we take some information from website, and I, in plain language, write in a Czech language, please write about the situation that Ondra was closing some big M&A transaction, and voila, there is a marketing material which is made, I don't know, in 3 minutes. So these are the use cases to use in your law firm or any legal company, because we made, for example, HR internal communication, HR internal bias, marketing materials for our clients, marketing information about new judicial decisions, because we are able to summarize them into 5 or 3 words. You know, it's up to you. How will you use the ChatGPT? And strongly, and I strongly believe that it's very great, great opportunity for you. And if you want to talk and think about that in an traditional way. Don't invent the wheel, because everything was there, and you can use old principles. Train it. Say to it that you can use some old materials. Say to the ChatGPT, ask me if you don't know what is the basic principles of my question, and take this and use to do that. So I wish you luck with ChatGPT, and my main purpose to attend this conference is to be in touch with people who is keen on artificial intelligence. So I will be really glad if we can connect on LinkedIn and exchange some information about artificial intelligence in the future. Thank you and have a nice day.
Thank you very much, Jakub. So it was really an insightful and entertaining presentation, I guess. Before I will, I don't know, Adrian, can I place the questions now or later better?
However you like, you are the moderator, you know.
Yeah, so basically I think it's better to ask them directly, right, since you already presented. So, I mean, for me it would be interesting to know what are, from your perspective, the biggest challenges while implementing AI into the legal teams?
People, definitely people, because, you know, we are working with attorneys with egos, and it's very traditional industry, and I really respect my people, so I want to give them good chance, but I don't want to force them to use it, so it's a quite a long way to introduce it to my people.
So, I mean, can you give an estimation, I mean, in terms of time? So, what do you think?
No, I think that this is a long time process of about 2 years to full implementation. I have to say that we cooperate with Walters Kluwer Czech Republic. They had system Pretor, which is a DMS system, and they implement the ChatGPT into Word. And I think that this will be the game changer when you will have ChatGPT in the Word or Office 365. Of course, you know all the systems that you are developing, and I really enjoy to see it in live.
Yeah, cool. Thank you very much. I would say let's go to the next presentation. Adrian.
Hello. Perfect.
Please go ahead then.
Pointer. Hello everyone, I'm Adrian, the CEO and co-founder of Vatistech. Vatistech is a speech-to-text company that develops a really accurate algorithm that can transcribe your audio into text. Speech-to-text technology advanced a lot in the last years, but still has a long way to go. Existing solutions are inaccurate and inefficient, which can lead to frustration for the end user, and which can lead to waste a lot of time and money. And that is the reason that we chose to implement our technology, you choose to develop a new technology, a really accurate technology that can perform this transcription task with a high accuracy, more exactly a human level accuracy. Our technology breaks the human level barrier, which is over 95% of accuracy in multiple domains, including the legal domain. But how we can use this technology? Our technology, it's first of all available in multiple languages. We started, of course, with the Romanian language because we saw a massive gap in the market. But our technology, it's covering billions of speakers at the moment. And we believe in a future without language barriers. But how can this technology be used on the legal field? For example, you can transcribe the court proceedings using the speech-to-text technology. You can transcribe what's happening and create accurate and immediate records. And in Romania, we have a lot of customers from that field. Also, you can transcribe your legal document. You can transcribe your interview with your clients or other parties. Or you can really dictate in real time your notes as a lawyer and create records from that dictation. And of course, you can use the speech-to-text technology to autocomplete the contract information by transcribing spoken details from your conversation with your clients. And after the meeting, after the conversation, you can automatically send that contract with field information to your customer. From the point of view of benefits of implementing and using a speech-to-text technology, first of all, you can save time and money. You can save a lot of time and money with faster transcription and document creation. And of course, you can reduce the need for manual transcription services. For example, you can no longer need to require the transcription for your team members of your interviews or something like that. Moreover, you can improve the accessibility. Imagine you have a lot of meetings, a lot of interview with your customers, with your clients, but it's really difficult to search through them. So basically, with speech-to-text technology, you can archive in a really indexable and easy to search way your entire meetings with your clients. Of course, you can increase the competitive advantage beside your competition. You can stay ahead with modern technology adoption. And nowadays, the company that implement and using technology can really have a really good competitive advantage. And it's a must-have from our point of view. Of course, you can optimize the resource. It's a better resource allocation, freeing up human resources from transcription task, from high-value work. For example, you can use the same people to do tasks with a better return of investment for your company instead of using them to transcribe your meetings. And last, of course, you can analyze and extract insights from all these meetings, from all this transcription. Imagine you have a lot of meetings during the year, but how really fast can you extract at the moment insight from all of these meetings? It's a little bit harder to extract meetings from your meetings right now. Our technology, it's already used by multiple customers from Romania on multiple use cases. Customers from the legal field, it's one of our main domain, but also our technology is used in multiple domains today. And in the end, we have a small demo. Can you play it?
Dacă plângerea prealabilă nu mai este obligatorie, pentru organismele sociale interesate în litigiile ce vizează autorizațiile de construire. Termenul pentru introducerea cererilor de anulare, suspendare, intervenție accesorie sau intervenție principală este de 60 de zile și începe să curgă de la data ultimei operațiuni de publicitate reglementată conform articolului 7 alineatul 23 indice 4. Deci observăm aici că în acest moment legea creează două categorii de persoane care pot ataca din cadrul categoriei terților, da? Care pot ataca un act administrativ în domeniul urbanismului. Avem persoanele fizice, să zicem vecinii, mai mult sau mai puțin îndepărtați, pentru că nu doar vecinii direcți, poate să fie un vecin care e pe aceeași stradă și care să aibă interes să atace o autorizație, dacă, să zicem,
în domeniul concurenței sunt permise acorduri de asociere între concurenți în plan orizontal, deci pe aceeași piață, cum sunt producătorii de energie electrică, în condițiile în care astfel de acorduri sunt benefice, produc beneficii, de exemplu prețuri mai mici și nu duc la o limitare a concurenței. Deci nu ar fi un cartel, ci ar fi pur și simplu un acord de cooperare. Sunt chiar categorii anume pe care, de exemplu, Comisia Europeană le definește în materie de cercetare, dezvoltare, în diverse domenii, în care astfel de acorduri ar putea fi permise. Deci, dacă în loc de doi monoliți, acorduri de asociere care să permită o mai mare, să zicem, dinamică în piață, nu neapărat să-l ajute pe cel slab să fie mai, adică, de exemplu, producătorul termo, care are un preț mai mare, și să zicem, să echilibreze jocul.
Simple API call. Our transcriptions also include a post-processing layer, which means will automatically add punctuation, capitalization, and make your transcript more, let's say, good to, or looking good from the point of view of the text. Also automatically detect the speakers from your meetings and associate from each speaker a unique label. Thank you so much. I'm looking forward for the questions.
Thank you very much, Adrian. So it was really an exciting presentation also to see how it really works in real life. I don't know if anyone in the audience has questions. But to me, it would be interesting to understand or to ask you, what do you think from your point of view is the future of the speech-to-text in the legal domain?
Thank you for your question. It's a really good question. From my point of view, the AI, it's here to stay. Doesn't matter if you like or don't like the technology, doesn't matter if you care about technology, but AI technology, it's here to stay and of course improve our life. And from the point of view of speech-to-text technology, I think will be adapted more and more by different domains, including the legal domain. How I present before, imagine you can transcribe or you can dictate your notes. It's much faster to dictate and speech to a robot instead of typing. More exactly, 3 times faster than typing. So the technology will improve our life. The AI technology will improve our life and help us a lot. Doesn't matter it's just a speech-to-text technology, it's a ChatGPT or other kind of technology. It's here to stay and improve our life. Doesn't matter the end domain.
Thank you for sharing your outlook with us, Adrian.
Thank you.
So, ladies and gentlemen, I know we are a little bit behind our time, and you are already keen to the networking part. But we have one more presentation. It's last but not least, Cyprian. So basically, you've heard, you know, what we were talking about in terms of AI, its challenges, opportunities, and impacts. Maybe you could share your expertise, you know, from your point of view on that topics.
Thank you very much. Thank you very much to our colleagues from Wolters Kluwer inviting us. And thank you also for the audience that you have the patience to stay with us. It's very nice beginning of summer weekend. No, it's okay. No, it's okay. Good. So thank you very much. What I would like to point out, discussing about how the regulators are regulating the AI domain, as very well Larissa mentioned, and also the panelists in the previous panels, the EU regulator is insisting on some main points. From the whole regulation, we have to remind that it's always about ethics and transparency. So I think these are the key words that we have to remind when we're discussing about regulating the AI. Of course, the quality management, it's also a very important thing, and definitely protecting the human rights. So there are some key elements that we should keep in mind when we are discussing about AI, and we are discussing a lot these years about AI. As very well Adrian put this question, the regulation are mentioning very severe sanctions in case the rules are not respected. So the fines can reach the level of 40 million euro in an absolute figure, or 7% of an annual turnover calculated at the group level. So it's even worse. So if until now we were scared about GDPR fines when they appeared, well, it was like a very scary movie. Now we get acquainted, and so the regulator is insisting on these very big, huge fines in order to definitely to realize the importance of respecting the rules. So, as Larissa mentioned, there are some 5 categories of classes when we are speaking about this risk-based approach related to the feasibility of the artificial intelligence. So coming from or starting from the not acceptable risks, which is definitely forbidden in the EU, going to the high risks where some obligations, ex-ante obligations should be observed, and moving to the limited risk or minimum risk that is permitted without restrictions. So these are maybe the categories the regulation is speaking about. The application of the regulation is irrespective. If you are selling a system, an AI system, it's irrespective if you have the headquarters in EU or outside EU. So it will be mandatory to be applied by all of such persons. Regarding the, let's say, the compliance with regulations, what you can do in order to comply. So, irrespective of the fact that the regulation is not yet enacted, and we saw the time span, the expected time span until this piece of legislation will be enacted. However, I think we can start the preparation even from today. As very well Jakub mentioned, I think beside the DPO in an organization, I think the AI responsible person should be a present thing, a mandatory thing. So we don't have to wait until the regulation will be enacted to have such person in the organization. So first of all, the first step I think should be the identification. So you have to start with identification of such product. If there is anywhere in your organization a product using the AI or a service using the AI, then you have to classify in which of the categories is classified your product or service. Then definitely you should comply. So you have to see how your product or service is compliance with the rules, to evaluate, let's say, the compliance part. Then there is the model of the statement, the statement mentioned in the annex of the regulation that you have to fill in and to label actually the product or the service. Then we can definitely launch the product or the service, and after launching it, definitely you should permanently monitor the evolution and the functionality of that specific product or service. What it is to be mentioned also regarding, so this was the regulation. Then the other piece important is the directive. So the liability directive for the artificial intelligence, dealing with the burden of proof in case of such products. Actually, what the EU legislator wanted to do is that to assure for the users of the AI systems of products at least the same level of protection as the protection is assured for, let's say, a user of a traditional technology. And in order to make this, it came with this piece of legislation, with this directive, applied to the non-contractual fault-based civil law claims. It came with some elements. First of all, it empowers the courts, the national courts are empowered to disclose relevant evidence which are in their disposal about specific high-risk artificial intelligence systems that is suspected to cause damage. So this is a very important element that the directive is adding, as well as other elements that they are making the burden of proof for the users more easy. But not only the EU, let's say, regulator is let's say, preoccupied to come with a piece of legislation, but also the national one. Maybe most of you know that on 26th of September it was launched the national strategic framework for the artificial intelligence that is applicable at the national level, which it comprises a series of measures to be implemented starting 2023 until 2027 in order to contribute to the national strategy to adopt new digital technologies in the economy and in the society, of course, respecting the human rights and promoting the excellence and the trust in the products and the services using artificial intelligence. It is expected that until 2030, almost 70% of the Romanian companies or the companies doing business in Romania utilizing at least one artificial intelligence technology, irrespective of the category, and also this technology to generate almost 1.2% GDP increase. So also the national legislator is preoccupied of this phenomenon and definitely is aligned to the measures that the EU regulator already implemented. And this will assure a very good source of communication and information for the public and for the citizens. It will be used also in order to link different domains that are related with AI. It's either the innovation, competition, education, digitalization of public services, so on and so forth. So there is preoccupation at the level of the EU and of the national regulators, trying to respect the ethics and the transparency, as we said, two very important values that we should take into consideration when we're speaking about AI.
Thank you very much, Cyprian, for sharing your meaningful insights with us. But before everyone starts to move towards a networking event, I have a question. So from your point of view, what, let's say, on the national and EU, what are the national and European Union regulator are preparing the framework regarding the artificial intelligence? How are we moving there? What are the challenges? What are opportunities and risks?
Yes, as mentioned, definitely the regulators are very preoccupied about AI thing, and in the near future, these pieces of legislation, as mentioned, will be enacted. And as we saw, there is a high, let's say, preoccupation of the EU regulator, especially in order to come with some specific elements in order to ease the burden of proof in case of potential claims, non-contractual claims. And I'm pretty sure that also the national regulator will follow this thing. Actually, the EU regulator came with this regulation and with this directive, trying to let's say help or to align, to give like a benchmark to the national regulators in order not to have fragmented, let's say, national laws, trying to be applicable for this, and maybe also helping the courts not to apply some ad hoc rules, trying to set up some cases that they have in front of them. So I really think that will help a lot this piece of legislation, the future activities and let's say the whole environment, the whole AI environment.
Interesting, thank you. And I have one last question. During the lunch break, you told me that you have a team of legal professionals of 80 people. So I'm curious, what's from your perspective, what do you think would be a possible AI solution for banks' legal departments?
Yeah, definitely we are preoccupied with this, and I was very happy to see the presentation of Adrian. I just found a very useful instrument that definitely will be and can be used also by the legal departments in banks. I don't know, helping to redact the minutes of different meetings, commissions, whatever things, board of directors meetings, so on and so forth. Very useful. But beside this, definitely in our activity we are trying to make the work in an efficient way. So we were thinking how to do it in such a way in order to be more efficient. So we saw that the research activity, it was one of the activity which was a very time-consuming activity. For instance, when it is about to search in the court decisions, or I don't know, in various decisions, irrespective if we are speaking about the national courts or I don't know, ECJ or other European courts. Being a huge volume of data there, definitely the artificial intelligence might help shortening the timing of searching this huge amount of database and let's say structuring the data in such a way to be very easy to be used by the lawyers in their activity. And definitely, I fully agree with Jakub, what Jakub said. Such a tool can do, let's say, the job very well, replacing sometime a paralegal and being maybe X time more efficient than such a person. Okay, there is also the reverse of this thing. I saw recently a study when some guys analyzed the results of some artificial intelligence programs, and even if apparently such programs, they were fed with some inoffensive, so not offensive data, the conclusions were like scary. I mean, if you see such a tool analyzing a text that you put it in a Facebook or in a LinkedIn, whatever post. So such a tool to analyze that text and to predict and to conclude that it was written by a young white guy, 34 years, having his apartment somewhere in New York near to whatever thing. So reaching this level of detail, definitely we have to think that this can be used also in a not a very, let's say, good intention way. So somebody might take a text, feed it to such a tool, and finding a lot of information about the person who wrote the specific text, accepting the copy paste. When, you know, if you just copy paste, then the conclusion might not be accurate. So anyway, so coming back to your question, as we said, searching in big volumes of data, definitely it's one of the things where the artificial intelligence might be used in the legal department of a bank. Then, I don't know, searching in different pieces of legislation regarding, I don't know, ECJ or international sanctions that we are dealing now more recently. Okay, during the wars, you are dealing also with some documents enacting some international sanctions, and these documents are continuously, let's say, modifying. So it's very hard to be updated all the time with all this information. So such a tool, I think, might be very, very useful also in this activity. Another thing that I'm thinking might be in the activity of preparing the legal documentation, the contractual documentation, or they say the financing documentation in some financing operations. When you are using a standard, usually you are using a standard of documentation, but not all the time the final document that you have to use is the one in a standard way. So sometimes you have to negotiate with the customers or with the other participants, let's say in a syndicated loan or something. And you ended up with a form of a document which you would be interested to see how much is respecting the standard clauses that you have in a standard documentation. So again, it's a matter of timing. Instead of having one people trying to compare two versions of the document, you very easily might have a tool, an AI tool, comparing the two documents and telling you about what clauses have been modified, what clauses are missing, so on and so forth. So again, I think this is a very important field where the artificial intelligence might help at least legal departments in banks.
Thank you, Cyprian, for your comprehensive answer. So before closing, maybe thanks a lot to my colleagues for sharing your important information with us and insights. Ladies and gentlemen, thank you for your patience and endurance, also for the colleagues who are joining us or watching us online. And before we will close the session and move towards the networking part, I would like to hand over to Adrian for the closing words. Thank you very much.
Thank you again. Indeed, we had a full day and we found out that we know nothing. This is what I found out actually. I saw so much technology. I just realized that having years of experience of computing, working on the computer means almost nothing, because this is a new animal. It's a new breed. And we have indeed the two options: to let it pass by or try to put the hand on it and try to actually control this technology. Otherwise, indeed, it will control us at some point. That will be like, what happened? We don't know what happened. And I think the best similarity that I can find is we all went on a plane and flew somewhere, and let's say that tomorrow we purchase a plane. We purchase ChatGPT, but like a pilot will never be without the training. So after we purchase some AI technology and we try to implement in our company, the problem is the next day after the purchase we'll just be the owners of that technology, but we'll not know how to handle it unless we have a certificate in order to handle that airplane. So you need to be a pilot, you need to be trained to use that new technology. Thank you all for being today at this fourth edition of Legal Innovation Day. I hope you had a great time. I hope you find some answers and many questions, I'm guessing. So this is why I invite you to the networking side, so you can maybe solve some of those. Thank you very much, and thank you to all our speakers.